Investment Advisor Law. Exam License Exam Manual. Series 65. 11th edition. S65_LEM.INB 1 15th of March 2019 10:57 and 44. At press time, this edition contains the most complete and accurate information currently available. Owing to the nature of license examinations, however, information may have been added recently to the actual test that does not appear. Uniform Investment Advisor Law. Exam License Exam Manual. Series 65. 11th edition. S65_LEM.INB 1 15th of March 2019 10:57 and 44 seconds AM. Kaplan. At press time, this edition contains the most complete and accurate information currently available. Owing to the nature of license examinations, however, information may have been added recently to the actual test that does not appear in this edition. Please contact the publisher to verify that you have the most current edition. This publication is designed to provide accurate and authoritative information in regard to the subject matter covered. It is sold with the understanding that the publisher is not engaged in rendering legal, accounting, or other professional services. If legal advice or other expert assistance is required, the services of a competent professional should be sought. Copyright Symbol 2019 Kaplan Incorporated. The text of this publication, or any part thereof, may not be reproduced in any manner whatsoever without written permission from the publisher. If you find imperfections or incorrect information in this product, please visit www.kaplanfinancial.com and submit an errata report. Published in March 2019 by Kaplan Financial Education. Revised October 2019. Printed in the United States of America. Series 65 Uniform Investment Advisor Law Exam License Exam Manual, 11th edition. ISBN 978-1-4754-7471-8. S65_LEM_copyright.INDD 2 the 7th of October 2019 10:45 and 50 seconds AM. Contents. Introduction 11. Part 1 LAWS, REGULATIONS, ANDGUIDELINES, INCLUDING Prohibitions on Unethical Business Practices. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered. Advisors 3 Learning Objectives 3 Introduction 3 The Uniform Securities Act of 1956, USA, for Investment Counsel 7 Sec Release IA, 1092 8 Exclusions 10 Exemptions 13 Private Fund Advisors 15 Registration Requirements for Investment Advisors 18 Dodd-Frank and Assets Under Management 18 How is Form ADV organized? 22 Financial Requirements for Registration as an Investment Advisor 27 Books and Records required by Federal and State Law 31 Supervisory Requirements 34.
Unit 2 Regulation of Investment Advisor Representatives, 37 Learning Objectives, 37 Introduction, 37 Investment Advisor Representatives, 37 IAR Exclusions and Exemptions, 38 Registration Requirements for Investment Advisor Representatives, 42. Unit 3 Regulation of Broker-Dealers and their Agents, 45. Learning Objectives 45 Introduction 45 Who is a broker-dealer?
45 Broker-dealer exclusions and exemptions 46 Who are agents? 50 Agent exclusions and exemptions 51 Broker-dealer registration requirements 54 Submitting an application 54 Payment of initial and renewal filing fees 56 Agent registration requirements 57 Limited registration of Canadian broker-dealers and agents 59. 3. S65_LEM.IN 3 the 15th of March 2019 10:57 and 44 seconds AM. Unit 4 Regulation of Securities and Issuers 61 Learning Objectives 61 What is a security under the Uniform Securities Act? 61 non-security investments, 63 issuer, 64 initial, or primary offering, 65 security exemptions from registration under the Uniforms Securities Act 65 exempt securities, 67 exempt transactions, 70 exempted securities under the Securities Act of 1933, 74 registration of securities under federal law, 77 registration of securities, 78 preliminary, red herring, prospectus, 79 methods of state registration of securities, 82 anti-fraud, 86. Unit 5 Remedies and Administrative Provisions, 89 Learning Objectives, 89 Administrators Jurisdiction, 89 Administrators Actions, 94 Non-Punitive Terminations of Registration, 101 Rights of Recovery from Improper Sale of Securities, 102.
102. Unit 6 Communication with Clients and Prospects, 109 Introduction, 109 Learning Objectives, 109 Disclosure of Capacity, 109 General Disclosure Requirements, 112 Misrepresenting a Securities Professionals Registration, 117 Performance Guarantees, 118 Investment Advisory Contract, 119 Investment Advisor Brochure Rule, 122 Social Media, including electronic communications, emails and text messages, 129 Advertising, 133. Unit 7 Ethical Practices and Fiduciary Obligations, 139 Learning Objectives, 139 Fiduciary Responsibility of Investment Advisors, 140 Cash Referral Fees, 144 Section 28 E Safe Harbor, 147 Other Brokerage Practices, 150 Rules on Custody of Funds and Securities, 151 Investment Discretion, 156 Money Laundering, 159. For contents: S65_LEM.INDB 4 March 15, 2019, 10:57 and 44 seconds AM. The Prudent Investor Rule 159 Statement of Policy on Dishonest or Unethical Business Practices of Broker-Dealers and Agents, 160 Practices relating solely to agents, 164 Nassau Model Rule on Unethical Business Practices of Investment Advisors, Investment Advisor Representatives, and Federal Covered Advisors, 165 Criminal or Unethical Activities, 166 Compliance Programs, 171 Investment Advisor Reporting, 172 Cybersecurity, Data Protection and Privacy, 175 Methods for Protecting the Firm and its Customers, 178 Privacy, Regulation, SP 179 Business Continuity and Succession Plans, 181. Part 2 Economic Factors and Business Information. Unit 8 Basic Economic Concepts, 185 Learning Objectives, 185 Fundamental Economic Principles, 185 Major Schools of Economics, 186 Balance of Payments, 188 Top-Down and Bottom-Up Analysis, 190 The Business Cycle, 191 Inflation and Deflation, 194 Yield Curves and Interest Rates, 199. Unit 9 Financial Reporting, 205. Learning Objectives, 205 Financial Statements, 205 Accounting Fundamentals, 214 Cash Flow Statement, 215 SEC Reporting Forms, 217.
217. Unit 10 Analytical Methods, 219 Learning Objectives, 219 Time Value of Money, 220 Measures of Central Tendency, 224 Income in Perpetuity, 227 Exhausting the Principal, 227 Beta Coefficient, 229 Alpha, 229 Standard Deviation, 231 Correlation Coefficient, 233 Balance Sheet Ratios, 234 Market Price Related Ratios, 238. Contents v. S65_LEM.IND 5 the 15th of March 2019 10:57 and 44 seconds AM. Unit 11 Types of Investment Risk, 241 Learning Objectives, 241 Systematic Risks, 241 Unsystematic Risks, 244 Opportunity Cost, 247 Liquidation Priority, 248. Part 3 Investment Vehicle Characteristics. Unit 12 Types and Characteristics of Equity Securities, including methods used to determine their value, 251 Learning Objectives, 251 Equity Securities, 252 Common Stock, 252 Basic Features of Equity Securities, 253 Benefits and Risks of Owning Common Stock, 256 Types of Preferred Stock, 257 Benefits and Risks of Owning Preferred Stock, 260 Employee Stock.
Stock options 260 restricted stock 262 American depository receipts 263 investing in foreign markets 265 fundamental analysis 266 technical analysis 268 technical market theories 269 Unit 13 Types and characteristics of fixed income, debt, securities and methods used to determine their value 271 Learning objectives 271 Fixed income, debt securities 272 U.S. government securities 272 GNMA securities 275 bond pricing 277 bond listings 278 secured debt 278 ratings 280 municipal bonds 282 tax equivalent yield 283 foreign bonds 284 Brady bonds 286 repaying debt principal 287 convertible bonds 289 computing parity price 290 6 contents S65_LEM.INV 6 the 15th of March 2019 10:57 and 45 seconds AM. Advantages and disadvantages to convertible securities 291 bond yield computations 292 price yield relationship summary 298 duration 299 discounted cash flow DCF 301 money market instruments 303 bank deposit accounts 306 Unit 14 Types and characteristics of pooled investments 309 Learning objectives 309 The Investment Company Act of 1940 310 Types of investment companies 310 Capitalization of management investment companies 315 Pricing of management investment companies 316 Mutual fund share classes and loads 318 Private funds 323 Hedge funds 324 Unit investment trusts, UITs 326 exchange-traded funds, ETFs, 327 real estate investment trusts, REITs, 328 benefits and risks of pooled investments 330. Unit 15 insurance-based products 337 Learning objectives 337 Types of annuities 337 Variable annuities 338 is a variable annuity a mutual fund. 340 Index annuity 342 Purchasing annuities 343 Receiving distributions from annuities 344 Taxation of annuities 347 Life insurance 349 Variable life insurance 354 Variable life special features 358 Unit 16 Types and characteristics of derivative securities 361 Learning objectives 361 Derivative securities, options 361 Puts and calls 362 Options strategies 365 Rights and warrants 368 Non-securities derivatives, forward contracts 370 Investing in derivatives 372 Contents 7 S65_LEM.INV 7 the 15th of March 2019 10:57 and 45 seconds AM. Unit 17 Alternative investments and other assets 377 Learning objectives 377 Direct participation programs, DPPs, 378 Investors in a limited partnership 378 Issuing partnership investments 380 Viatical life settlements 383 Investment real estate 384 Commodities 384 Benefits and risks of alternative investments 385 Part 4 Client Investment Recommendations and Strategies. Unit 18 Type of Client 391 Learning Objectives 391 New Account Agreement 391 Account Ownership Categories 392 Accounts for Business Entities 397 Choosing the Right Business Structure 399 Fiduciary Accounts 400 Trust and Estate Accounts 402 Foundations and Charities 405 Estate Planning Options 407 Trust Suitability Issues 410 Unit 19 Client Profile 411 Learning Objectives 411 Client Financial Status 411 Financial Profile 412 Non-Financial Considerations 413 Risk Tolerance 414 Investment Objectives and Investment Constraints 416 How to make suitable recommendations 423 Unit 20 Portfolio Management Styles, Strategies, and Techniques for 29 Learning Objectives for 29 Asset Allocation Classes for 30 Benefits of Diversification for 31 Tactical Asset Allocation for 32 Strategic Asset Allocation for 33 Rebalancing for 34 Low Cost Management Strategies for 35 Growth versus Value for 36. 8 Contents S65_LEM.IN date the 15th of March 2019 10:57 and 45 seconds AM. Other portfolio management styles for 37 market capitalization levels for 39 minimizing interest rate risk for 40 capital market theory for 42 modern portfolio theory for 42 efficient portfolios efficient frontier for 40 for the security market line for 45 the efficient market hypothesis EMH $446 cost averaging for 48 hedging with equity options for 49. Unit 21 tax considerations for 51. Learning objectives for 51 individual taxation for 51 sources of income for 53 tax treatment of capital gains and capital losses for 58 alternative minimum tax AMT 462 taxation of life insurance for 62 taxation of social security for 64 capital gains taxation on donated, gifted, and inherited securities for 64 estate taxes for 67 donors gift tax obligation for 68 taxation of businesses for 71 filing dates for business tax returns for 72. Unit 22 trading securities for 75. Learning objectives for 75 cash and margin accounts for 75 margin account calculations 478 types of securities markets for 80 broker versus dealer for 82 trading costs for 83 bids, offers, and quotes 485 types of orders for 85 high frequency trading, HFD, 491 dark pools for 92. Unit 23 performance measures for 95. Learning objectives for 95 review of bond yields for 95 investment return measurements for 97 portfolio benchmarks 503. Contents 9. S65_LEM.IND known the 15th of March 2019 10:57 and 45 seconds AM. Unit 24 Retirement Plans including ERISA issues and educational funding programs 507 Learning Objectives 507 Introductory Note 508 Traditional IRAs 509 Roth IRAs 511 Simplified Employee Pensions, SEP IRAs 513 Withdrawals from Traditional IRAs and SEP IRAs 514 Characteristics of IRAs 516 KEO Plans 522 403B Plans, Tax-Exempt Organizations 524 Corporate-Sponsored Retirement Plans 527 Non-Qualified Retirement Plans 531 Distributions from Qualified Plans 533 Summary of Distribution Rules from both Qualified Plans and IRAs 535 Summary of Rollover and Transfer Rules 537 Employee Retirement Income Security Act of 1974, ERISA 538 Coverdell Education Savings Accounts 545 Section 529 Plans 547 UTMA Accounts 552 Unique Features of the Uniform Transfers to Minors, UTMA 555 HSAs 556. Appendix A 558 Appendix B 561 Appendix C 566 Glossary 572 Index 608. X Contents S65_LEM.IND 10 the 15th of March 2019 10:57 and 45 seconds AM. Thank you for choosing Kaplan for your educational needs and welcome to the Series 65 License Exam Manual, LEM. This manual applies adult learning principles to give you the tools you'll need to pass your exam on the first attempt. Why do I need to pass the Series 65 exam? Most states require passing a qualification examination by those who give investment advice, or perform certain related functions. The North American Securities Administrators Association, NASA, has created the Series 65 Uniform Investment Advisor Law Exam as one of the options that may be used to meet that requirement. Are there any prerequisites? There are no prerequisites to sit for the Series 65 exam. However, the test assumes that the applicant has a broad range of knowledge or experience with investments. Because a significant percentage of our students come to us without that background, this manual attempts to cover all of the basics as well as the more advanced material tested. Those of you with a Series 6 or Series 7 registration will find these basics a good review that will help set the stage for learning the intricate topics you will need to know. Examination waivers. Passing the Series 65 normally is a prerequisite to getting licensed as an investment advisor representative. However, most states will allow an individual to substitute one of the following certifications for passing the exam. CFP Registered Trademark Symbol Certified Financial Planner Trademark Symbol, granted by the CFP Board of Standards. CIC Chartered Investment Counselor, granted by the Investment Advisor Association. CHFC Registered Trademark Symbol Chartered Financial Consultant Registered Trademark Symbol, granted by the American College of Financial Services. PFS Personal Financial Specialist, granted by the American Institute of Certified Public Accountants, and CFA Registered Trademark Symbol Chartered Financial Analyst Registered Trademark Symbol, granted by the Chartered Financial Analyst Institute. The individual applicant still has to go through other state licensing requirements, such as filing a Form U4 or Form U10 and payment of fees. What is the Series 65 exam like? The Series 65 is a 3-hour, 140-question exam, 130 questions scored, prepared by the North American Securities Administrators Association, NASA, and administered by FINRA. It is offered as a computer-based exam at Prometric testing centers around the country. Introduction. 11. S65_LEM.int 11 15th of March 2019 10:57 and 45 seconds AM. What score must I achieve to pass? You need a score of at least 72%, 94 questions correct of the 130 scored, on the Series 65 exam to pass and become eligible for registration as a registered investment advisor representative. What topics will I see on the exam? The questions you will see on the Series 65 exam do not appear in any particular order. The computer is programmed to select a new, random set of questions for each exam taker according to the preset topic weighting of the exam. Each Series 65 candidate will see the same number of questions on each topic but will see a different mix of questions. The Series 65 exam is divided into 4 critical function areas. Number of questions percentage of exam. 1. Economic Factors and Business Information 2015. 2. Investment Vehicle Characteristics 3225-3. Client Investment Recommendations and Strategies 3930. 4. Laws, Regulations, and Guidelines, including prohibitions on unethical business practices 3930. When you complete your exam, you will receive either a notification that you passed, but no score, or a failing score with a printout that identifies your performance in each area. Preparing for the exam. How is the License Exam Manual organized? The License Exam Manual consists of 4 parts, chapters. Each of these parts corresponds to one of the function areas tested. Furthermore, each of the parts is divided into units covering specific areas within the part. Within each unit are a number of learning objectives, LOS, covering the testable material in that unit. The introduction to each unit indicates the LOS and the number of questions you can expect the exam to ask about that unit's material. For students attending one of our classes, live or online, the class lecture will follow the sequence of these units. On your dashboard, you will have the opportunity to create a study calendar customized to your personal schedule. Please follow it as it gives step-by-step details as to how to optimize your learning experience. Think of it as a roadmap. Don't take any detours or shortcuts and you will arrive safely at your destination, a passing score. In following Following the study calendar, you will be asked to use the Securities Pro TM Bank to create a test at the end of each unit. These tests are designed to repeat and reinforce the information presented in the reading. In order that the material being presented is properly explained, it sometimes happens that a term or phrase is used before its formal introduction in the course. In many cases, the term will be set off to the side with its definition. In other cases, you can consult the glossary for the definition or the index to locate a more complete discussion. 12 Introduction. S65_LEM.INT 12 the 15th of March 2019 10:57 and 45 seconds AM. You also may have access to a PDF copy of the LEM. If so, we strongly recommend that you download it, because you can use the search function to find specific terms quickly. In addition to the regular text, the LEM also has some unique features designed to help with quick understanding of the material. When additional emphasis is valuable to your comprehension, the following distinctions are made. Take note. Each take note provides special information designed to amplify important points. Test topic alert. Each test topic alert reviews content that is especially likely to appear on the exam. Example. Examples provide practical applications that convert theory into understanding. Additional study resources. To accompany and supplement your LEM, your study package may contain additional study resources. Be sure to spend some time on your dashboard, view the best practices video and read the PDF, and understand all that is available to help you study. Securities Pro trademark symbol QBank. Coordinating with the LEM, the Securities Pro TM QBank includes a large number of questions that are similar in style and content to those you will encounter on the exam. You may use it to generate tests by a specific unit or combination of units. The QBank also allows you to select weighted mock exams that simulate the topical composition of the Series 65 exam. There is no limit on the number of QBank exams you can create. One thing you should know about the Securities Pro TM QBank is that the answer choices are scrambled each time you take a test. That is, if the first time you saw a specific question, the correct answer was choice A, that statement might be choice D the next time. Please keep this in mind if you need to contact us regarding that question. Another important point is that the online questions are live. That is, unlike this manual, which, once printed, can't be changed, our questions can be updated with a moment's notice. This enables us to keep current with rule changes and, to the extent possible, with new topics as they are added to the Series 65 exam. When we author questions covering new material that is not in this manual, there will be an asterisk placed after the reference number, indicating the general area where this topic belongs and that there is no specific information dealing with it other than this, or similar, questions and the exam tips and content updates link. As a result of their being live, anytime there is a discrepancy between an online question and something in this LEM or one of our videos, the question is always correct. Introduction 13. S65_LEM.INT 13 the 15th of March 2019 10:57 and 47 seconds AM. Practice and mastery exams. Depending on the study package purchased, you may also have a fixed practice exam or a fixed practice and mastery exam. These exams are designed to closely replicate the true exam experience, both in terms of the degree of difficulty and topical coverage. They provide scores and diagnostic feedback, but you will not be given access to, or be able to obtain from Kaplan, correct answers or question explanations. The practice and mastery exams are sound indicators of potential actual exam scores. The better you do in these exams, the more likely you are to pass your actual exam. These may only be taken once each. Video library. You may also have access to various topics from our video library. These short, engaging videos cover key topics from your manual. If your package includes access to our video library, Please review the topics as you complete your reading assignments in the study manual. Because most of the videos are not exam-specific, you may encounter material that is not covered in your LEM. Just skip ahead until the slide shows something familiar. Exam tips and content updates link. Don't forget to monitor your exam tips and content updates, located on your dashboard, when rules and regulations change, or we want to share new information regarding your exam, it is posted there. And one more thing. In addition, try as we may, in a text this large, errors are difficult to avoid. When you become aware of them, we acknowledge them in the Corrections tab, also located on your homepage. What topics are covered in the course? The License Exam Manual consists of 4 parts, each devoted to a particular area of study that you will need to know to pass the Series 65. Each part is divided into study units devoted to more specific areas with which you need to become familiar. The Series 65 License Exam Manual addresses the following topics. Part Topic 1. Laws, regulations, and guidelines, including prohibitions on unethical business practices. 2. Economic factors and business information. 3. Investment vehicle characteristics. 4. Client investment recommendations and strategies. How much time should I spend studying? Plan to spend approximately 60 to 120 hours reading the material and carefully answering the questions. Spread your study time over the 4 to 5 weeks before the date on which you are scheduled to take the Series 65 exam. Your actual time may vary depending on your reading rate, comprehension, professional background. Those with a securities background will generally require less time, and that is the reason for the wide range in recommended study hours and study environment. 14. Introduction. S65_LEM.IND 14 the 15th of March 2019 10:57 and 47 seconds AM. What is the best way to structure my study time? The following schedule is suggested to help you obtain maximum retention from your study efforts. Remember, this is a guideline only, because each individual may require more or less time to complete the steps included. Step 1. Read a part, unit by unit, and complete all exercises. Review rationales for all questions whether you got them right or wrong. Time will vary based on the size of the unit. Step 2. In the Securities Pro QBank, create exams of the designated length for each unit as you go. Carefully review all rationales. Use the LO number to locate additional or related information on the test topic in your LEM if needed, 1 to 4 hours per unit. Be sure to do the checkpoint exams following each unit and the midterm exam after you have reviewed the Unit 2 checkpoint exam. These tests are generally more challenging than those in the QBank. They have been specifically selected to check your progress and ensure that you are prepared to move forward. Do not become too overwhelmed or bogged down in any one unit. You don't want to lose sight of the finish line because you're having trouble with one hurdle. Keep moving forward. It's a steady pace that wins the race. View rationales after each question initially and spend time studying each rationale in order to learn the concepts. Later, you will want to create exam scenarios in which scores and rationales are viewed at the end of each exam. Perfection is not the goal during the reading phase. A score in the high 60s to low 70s is good initially. Step 3. When you have completed all the units in the LEM and the unit tests you have created, using the Securities Pro QBank, concentrate on comprehensive exams covering all the material. With your comprehensive testing, it is best to view correct answers and rationales only after the test is completed. Plan to spend at least 1 week testing before a scheduled class, 4 hours for every 130 questions. You should complete at least 5 weighted mock, simulated, exams before class. Review all of your answers and rationales. Also, review your LEM and video library as needed. Your goal is to consistently score in the 80s. Step 4. Complete online practice and mastery exams. The online practice exam and mastery exam present you with questions from the topics covered based on their weighting and emphasis on the actual exam. Remember, you will not receive rationales for the answers you select, nor will you receive immediate feedback as you take the exam. We are simulating actual test conditions. You should complete these exams while observing the time limits for the actual exam. Upon completing the exam, you will receive a diagnostic report that identifies topics for further review, 3 to 4 hours per exam. Introduction 15. S65_LEM.int 15 the 15th of March 2019 10:57 and 47 seconds AM. Note: after completing practice, mastery, and mock exams, be sure to review your performance tracker so you can identify areas of weakness. You can then create custom quizzes focused on topics as needed. Also, review your LEM and video library for additional help. We recommend taking the practice exam shortly after a scheduled class and the mastery exam 2 to 3 days before your exam date. How well can I expect to do? The exams prepared by NASA are not easy. You must display considerable understanding and knowledge of the topics presented in this course to pass the exam and qualify for registration. If you study diligently, complete all sections of the course, and consistently score in the 80s on the simulated, mock, tests and achieve a passing grade on the practice and mastery exams, you should be well prepared to pass the exam. However, it is important for you to realize that merely knowing the materials will not enable you to pass unless you can apply your knowledge to the questions you are given and understand the essence of the information behind the question. Test-taking tips. Passing the exam depends not only on how well you learn the subject matter, but also on how well you take exams. You can develop your test-taking skills and improve your score by learning a few test-taking techniques. Read the full question. Avoid jumping to conclusions. Watch for hedge clauses. Interpret the unfamiliar question. Look for keywords and phrases. Identify the intent of the question. Memorize key points. Use a calculator. Beware of changing answers. Pace yourself. Each of these pointers is explained next, including examples that show how to use them to improve your performance on the exam. Read the full question. You cannot expect to answer a question correctly if you do not know what it is asking. If you see a question that seems familiar and easy, you might anticipate the answer, mark it, and move on before you finish reading it. This is a serious mistake. Be sure to read the full question before answering it. Mistakes are often made when assuming too much, or too little. 16. Introduction. S65_LEM.int 16 the 15th of March 2019 10:57 and 47 seconds AM. Avoid jumping to conclusions. Watch for hedge clauses. The questions on NASA exams are embellished with distractors as choices. To avoid being misled by seemingly obvious answers, make it a practice to read each question and each answer twice before selecting your choice. Doing so will provide you with a much better chance of doing well on the exam. Watch out for hedge clauses embedded in the question. Examples of hedge clauses include the terms if, not, all, none, and except. In the case of if statements, the question can be answered correctly only by taking into account the qualifier. If you ignore the qualifier, you will not answer correctly. Qualifiers are sometimes combined in a question. Some that you will frequently see together are all with except and none with except. In general, when a question starts with all or none and ends with except, you are looking for an answer that is opposite to what the question appears to be asking. Interpret the unfamiliar question. Do not be surprised if some questions on the exam seem unfamiliar at first. If you have studied your material, you will have the information to answer all the questions correctly. The challenge may be a matter of understanding what the question is asking. Very often, questions present information indirectly. You may have to interpret the meaning of certain elements before you can answer the question. Be aware that the exam will approach a concept from different angles. Look for keywords and phrases. Look for words that are tip-offs to the situation presented. For example, if you see the word prospectus in the question, you know the question is about a new issue. Sometimes a question will even supply you with the answer if you can recognize the key words it contains. Few questions provide blatant clues, but many offer keywords that can guide you to selecting the correct answer if you pay attention. Be sure to read all instructional phrases carefully. Take time to identify the keywords to answer this type of question correctly. Identify the intent of the question. Many questions on NASA exams supply so much information that you lose track of what is being asked. This is often the case in story problems. Learn to separate the story from the question. Take the time to identify what the question is asking. Of course, your ability to do so assumes you have studied sufficiently. There is no method for correctly answering questions if you don't know the material. Memorize key points. Reasoning and logic will help you answer many questions, but you will have to memorize a good deal of information. Some memorization will be automatic as you go over the material and answer questions, some you will simply have to do systematically. Introduction 17. S65_LEM.INT 17 the 15th of March 2019 10:57 and 47 seconds AM. Use of a calculator. For the most part, there are only a few questions that will require the use of a calculator. Any math will be simple math: add, subtract, multiply, and divide. We recommend using a calculator for math. A calculator will be supplied upon request. Avoid changing answers. If you are unsure of an answer, your first hunch is the one most likely to be correct. Do not change answers on the exam without good reason. In general, change an answer only if you discover that you did not read the question correctly, or find new or additional helpful information in another question. Pace yourself. Some people will finish the exam early and some do not have time to finish all the questions. Watch the time carefully. Your time remaining will be displayed on your computer screen, and pace yourself through the exam. Do not waste time by dwelling on a question if you simply do not know the answer. Make the best guess you can, mark the question for record for review, and return to the question if time allows. Questions are presented in a bell-shaped curve of difficulty, meaning the easiest questions are generally at the beginning and the end of the test. Make sure that you have time to read all the questions so that you can record the answers you do know. The exam. How do I enroll in the exam? To obtain an admission ticket to a NASA exam, you or your firm must file an application form and processing fees with FINRA. To take the exam, you should make an appointment with a Prometric testing center as far in advance as possible of the date on which you would like to take the exam. You may schedule your appointment at Prometric 24 hours a day, 7 days a week, on the Prometric secure website at www.prometric.com. You may also use www.prometric.com to reschedule or cancel your exam, locate a test center, and get a printed confirmation of your appointment. To speak with a Prometric representative by phone, please contact the Prometric Contact Center at 1-800-578-6273. What should I take to the exam? Take one form of personal identification with your signature and photograph as issued by a government agency. No personal items, food, or drink, including coffee and water, are permitted inside the testing room. Personal items include, but are not limited to, pens, pagers, cellular phones, watches, hats, non-medical electronic devices, outerwear, purses, and wallets. Personal items must be kept in your assigned locker or returned to your car before the start of your exam. As the testing vendor is not responsible for any personal items, they encourage you to bring only your identification into the center. 18 Introduction. S65_LEM.INB 18 the 15th of March 2019 10:57 and 47 seconds AM. Erasable noteboards and pens will be provided to you upon admittance to the testing room. If you need additional noteboards or pens, please alert your proctor. The noteboards and pens must be returned at the end of your exam. If you need a calculator for your testing session, please see the test center administrator. You will be provided with a non-programmable, non-printing calculator. Additional trial questions. During your exam, you will see 10 extra trial questions, that is why the test is 140 questions long. These are potential exam bank questions being tested during the course of the exam. These questions are not identified as such and are not included in your final score. Exam results and reports. At the end of the exam, you will receive either a notification that you passed, but no score, or a failing score with a printout that identifies your performance in each area. The testing center will print your results and affix their stamp as physical evidence of your passing. The next business day after your exam, your results will be mailed to your firm and to the self-regulatory organization and State Securities Commission specified on your application. Introduction 19. S65_LEM.INB 19 the 15th of March 2019 10:57 and 47 seconds AM. S65_LEM.INB 20 the 15th of March 2019 10:57 and 48 seconds AM. This part consists of 7 units. Unit 1 Regulation of Investment Advisors, including state-registered and federal-covered advisors. Unit 2 Regulation of Investment Advisor Representatives. Unit 3 Regulation of Broker-Dealers and their agents. Unit 4 Regulation of Securities and Issuers. Unit 5 Remedies and Administrative Provisions. Unit 6 Communication with Clients and Prospects. Unit 7 Ethical Practices and Fiduciary Obligations. In total, there will be 39 questions on this material, representing 30% of the Series 65 exam. 1. Part. Laws, regulations, and guidelines, including prohibitions on unethical business practices. 1. S65_LEM.INB 1 the 15th of March 2019 10:57 and 48 seconds AM. 65_LEM.INB 2 the 15th of March 2019 10:57 and 48 seconds AM. Investment advisors are defined by federal and state securities laws. A person that performs the functions of an investment advisor, as the term is defined in the Uniform Securities Act or the Investment Advisors Act of 1940 and more fully described in Securities and Exchange Commission, SEC, Release IA 1092. Is by definition an investment advisor. Investment advisors must conduct business within the regulatory framework prescribed in federal and state securities laws. The Series 65 exam will include approximately 6 questions on the material presented in this unit. Learning objectives. When you have completed this unit, you will be able to accomplish the following. UNLO1. Define investment advisor. UNLO2. Explain the impact of SEC Release IA 1092 on the definition of investment advisors and their activities. UNLO3. Identify exclusions and exemptions under the Investment Advisors Act of 1940 and the Uniform Securities Act. UNLO4. Identify the exempt reporting advisor and private fund advisor exemptions. UNLO5. Describe the investment advisor registration process, required post-registration filings, and business activities. UNLO6. Recognize that investment advisor representatives must be adequately supervised. Introduction. Before we can get started, we need to know a few things. Because this part of the course deals with laws and regulations, it is necessary to know what laws are involved. When it comes to the regulation of investment advisors, On the federal level, we have the Investment Advisors Act of 1940. On the state level, it is the Uniform Securities Act. This exam is the property. 1. Unit regulation of investment. Advisors, including state registered and federal. Covered advisors. 3. S65_LEM.INT 3 the 15th of March 2019 10:57 and 48 seconds AM. Of NASA, the North American Securities Administrators Association, the group of state, provincial, and Mexican regulators. Although the exam will ask about state and federal law, if it doesn't specify, the default choice is always state law. Let's investigate that law a bit. The Uniform Securities Act of 1956, USA. The USA is model state securities legislation. With the enactment of numerous state securities laws, commonly referred to as blue sky laws, the need for uniformity in securities laws among the states arose. In 1956, the original Uniform Securities Act was drafted as model legislation for the separate states to adopt. As model legislation, the USA is not actual legislation. The USA is a template or guide that each state uses in drafting its securities legislation. The securities laws of most states follow the USA very closely, and, in many cases, almost exactly. Take note. The term state means any of the 50 states, any territory or possession of the United States, such as American Samoa, Guam, and the Virgin Islands, the District of Columbia, and Puerto Rico. Test topic alert. The exam will test your knowledge of the Uniform Securities Act, not the specifics of your state's securities legislation. The USA is periodically updated to adjust to developments in the securities markets through the passage of model rules. You will be tested on the 1956 version of the USA used by the North American Securities Administrators Association, NASA, the advisory body of state securities regulators responsible for the content of the exam. The Series 65 exam requires that you not only know what the USA says, but also are able to apply the law to concrete situations. General knowledge of the law is not enough to pass the exam. You will be asked to apply the law to situations that may arise in the course of business. Definition: Administrator. Possibly the most used term in the exam is administrator. What is this? Although some states may use other terms to describe this position, the exam will only use the word administrator to refer to the office or agency that has the complete responsibility for administering the securities laws of the state. Therefore, the administrator has jurisdiction over almost all securities activity that emanates from his state as well as that received in his state. The administrator has jurisdiction over the registration of securities professionals and securities. He has the power to make rules and issue orders. He can deny, suspend, or revoke registrations. Yes, there are some limitations on the administrator's powers, and those will be covered in this course, but overall, this is one very powerful person. For Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.INT for the 15th of March 2019 10:57 and 48 seconds AM. U1L01. Define investment advisor. The definition of investment advisor is virtually identical under state law, the Uniform Securities Act, and federal law, the Investment Advisors Act of 1940. Here is how it is worded in the Uniform Securities Act. Investment advisor means any person who, for compensation, engages in the business of advising others, either directly or through publications or writings, as to the value of securities or as to the advisability of investing in, purchasing, or selling securities, or who, for compensation and as a part of a regular business, issues or promulgates analyses or reports concerning securities. Definition: Person as defined in the Uniform Securities Act. Person means an individual, a natural person, a corporation, a partnership, an association, a joint stock company, a trust where the interests of the beneficiaries are evidenced by a security, an unincorporated organization, a government, or a political subdivision of a government. For test purposes, it is easiest to remember the three non-persons. They are 1. A minor, 2. A deceased individual, and 3. An individual declared mentally incompetent by the courts. Example: a person is basically anyone that can open an account. The test would be looking for you to choose an answer to a question such as this. 1. Which of the following is included in the definition of person? A. The minor. B. The National Basketball Association. C. A deceased person. D. A person whom the courts have declared to be mentally incompetent. Answer: B. Not to think of the NBA as a person, but they would be included in the USA's definition. That is why questions are much easier if you just remember the three things that are not a person. The definition of investment advisor is sometimes referred to as the three-prong test. That is, as long as the person involved gives advice to others on securities, does so as part of a regular business activity, and receives compensation for performing this activity. Let's examine each of those. Giving advice to others on securities: persons will meet the first prong of the test if they provide advice to others about specific securities, such as stocks, bonds, mutual funds, and limited partnerships, as well. How to. Unit 1. Unit 1: Regulation of Investment Advisors, including state-registered and federal covered advisors. 5. S65_LEM.IND 5 the 15th of March 2019 10:57 and 48 seconds AM. Allocate assets among a group of securities. Even indirect advice can be included. Examples of this could be: why should you invest in securities as compared to non-securities investments, such as insured bank CDS or rental property? Here is our view on future stock market trends. The advice can be in written or oral form. That is, it can be part of a printed, or online, report or advice given on a phone call. The regulators, both state and federal, have stated that advice on many other types of investments is not advice about securities. Some of the specifically mentioned non-securities investments include commodities, collectibles, such as coins or stamps, precious metals, such as gold and silver, and real estate. Take note: the list of what is a security and what is not a security will be covered in more detail at Unit 4, LO1. Example 1. A person giving advice on which of the following investments would be deemed to be giving advice on securities. A. Gold. B. Common stock. C. Rental real estate. D. Rare stamps. Answer: B. Common stock is a security, the others are considered non-securities. In the business of providing advice: persons are in the business of providing advice and meet the second prong, defining one as an investment advisor if they do the following: give advice on a regular basis such that it constitutes a business activity conducted with some regularity. Although the frequency of the activity is a factor, it is not the only determinant in whether one is in the business of giving advice. Furthermore, providing advice does not have to be the person's principal activity. Advertise investment advisory services and presents himself to the public as an investment advisor or as one who provides investment advice. Example: as an example, a person is an investment advisor if she recommends that a client allocate funds to specific assets, such as high-yield bonds, technology stocks, or mutual funds. Specificity is the term used to describe this activity and invariably fulfills the in the business requirement. 6. Unit 1: Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.IND 6 the 15th of March 2019 10:57 and 49 seconds AM. A person whose business is to offer only non-specific investment advice, through publication of a general newsletter, for instance, is not covered by the Act. That exclusion will be covered shortly in LO3. Compensation. A person who receives any economic benefit as a result of providing investment advice meets the third prong. Compensation includes advisory fees, commissions, or other types of fees relating to the service rendered and can be directly or indirectly paid. Example: when a person designs a comprehensive financial plan for an individual, but does not charge a fee for that design, electing to be compensated solely through commissions received on the sale of insurance policies sold as part of the plan, that is considered compensation. Even though that compensation is indirect, it meets the release's definition of compensation for investment advice. Investment counsel. One of the terms that may appear on the exam is that of investment counsel. Questions dealing with this topic require the student to know that two criteria specified in the Investment Advisors Act of 1940 must be met to use the term to describe the nature of the IA's business. They are as follows. The IA's principal business must be giving investment advice. This basically excludes financial planners and others for whom investment advice is only a part of what they do. Provide investment supervisory services. This one is a bit harder for most to understand, so here are some details as issued by the SEC. Continuous and regular supervisory or management services. General criteria. You provide continuous and regular supervisory or management services with respect to an account if A. You have discretionary authority over and provide ongoing supervisory or management services with respect to the account, or B. You do not have discretionary authority over the account, but you have ongoing responsibility to select or make recommendations, based upon the needs of the client, as to specific securities or other investments the account may purchase or sell, and, if such recommendations are accepted by the client, you are responsible for arranging or effecting the purchase or sale. You do not provide continuous and regular supervisory or management services for an account if you A. Provide market timing recommendations, i.e., to buy or sell, but have no ongoing management responsibilities. B. Provide only impersonal investment advice, example, market newsletters. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors 7. S65_LEM.INT 7 the 15th of March 2019 10:57 and 49 seconds AM. C. Make an initial asset allocation, without continuous and regular monitoring and reallocation, or D. Provide advice on an intermittent or periodic basis, such as upon client request, in response to a market event, or on a specific date, example, the account is reviewed and adjusted quarterly. Point 1. Example 1. Which of the following investment advisors would be permitted to use the term investment counsel? A. A financial planner offering a wide range of services to his clients, including tax planning, estate planning, and insurance planning, as well as investment advice. B. A professional providing a market timing service with an annual subscription fee of $495. This service attempts to maximize profits by suggesting entry and exit points for over 100 listed stocks. C. A firm whose exclusive business is placing their clients' assets into model portfolios that are monitored on a daily basis. D. All of these. Answer. C. To use the term investment counsel, two criteria must be met. The principal business must be giving investment advice and the advisor must provide investment supervisory services. Running model portfolios for clients with daily monitoring would meet both requirements. The financial planner is not principally in the business of offering investment advice because he describes his service as offering a wide range of services, of which advice is only one part. The exam frequently uses that wording to indicate that advice is not the principal activity. While the market timing publisher's principal business activity may be offering advice, nothing about the description indicates that individual client accounts are being monitored. SEC Release IA 1092. UNLO2. Explain the impact of SEC Release IA 1092 on the definition of investment advisors and their activities. As a result of the proliferation of persons offering investment advice in the 1980s, Congress directed the SEC to define the activities that would subject a person to the 1940 Investment Advisors Act. The SEC did so in SEC Release IA 1092 in October 1987. SEC Release IA 1092 interprets the definition of investment advisor under the Investment Advisors Act of 1940 to include financial planners, pension consultants, and others who offer investment advice as part of their financial practices. Much of the release was a repetition of existing law, such as the three prongs. The biggest impact was the expansion of the definition. Let's look at those who are directly affected. 1. Appendix B Form ADV. Instructions for Part 1A. 8. Unit 1 Regulation of Investment Advisors, including state-registered and federal-covered advisors. S65_LEM.IN date the 15th of March 2019 10:57 and 49 seconds AM. Financial planners. Financial planners who make recommendations regarding a person's financial resources or perform analyses that concern securities are investment advisors if such services are performed as part of a business and for compensation. Under this interpretation, the SEC holds that there is no such thing as a comprehensive financial plan that does not involve securities. Pension consultants. Consultants who advise employee benefit plans on how to fund their plans with securities are also considered investment advisors by the SEC. In addition, the SEC considers pension consultants who advise employee benefit plans on the selection, performance, and retention of investment managers to be investment advisors. Sports and entertainment representatives. Persons who provide financially related services to entertainers and athletes that includes advice related to investing, tax planning, budgeting, and money management are also investment advisors. As earnings for these celebrities continue to climb, more and more of them use personal managers to handle all of their finances, and those individuals or firms are generally going to be considered investment advisors. Take note. A sports agent who secures a favorable contract for a football player and receives a commission of 10% of the player's salary is not necessarily an investment advisor. However, if the sports agent advises the football player to invest his money in specific securities, the agent is then in the business of offering investment advice and would then be subject to the Investment Advisors Act of 1940 or the Uniform Securities Act. Example. 1. Under SEC Release IA 1092, which of the following is most likely to meet the definition of an investment advisor? A. A person who sells long-term care insurance. B. A person who advises businesses on the best location for their stores. C. A person who assists pension plans in the selection of portfolio managers. D. A person who manages portfolios of investment-grade coins. Answer. C. This is the role of a pension consultant. Unless the insurance has a securities aspect, selling it would not be considered investment advice. Real estate and coins are not securities. UNLO 3. Identify exclusions and exemptions under the Investment Advisors Act of 1940 and the Uniform Securities Act. Because terminology is critical to jurisdiction, it is important to know the difference between excluded from a definition and exempt from a provision. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal-covered advisors. 9. S65_LEM.IND 9 the 15th of March 2019 10:57 and 49 seconds AM. Exclusion means excluded from, or not included in, a definition. For example, if a person is excluded from the definition of an investment advisor, that person is not subject to provisions of state or federal law that refer to investment advisors. There are a number of exclusions from the investment advisor definition available to persons who might well satisfy all three prongs of the definition, but, because of the provisions of the law, are specifically not defined as investment advisors. An excluded person is not subject to any provisions of the Investment Advisors Act or the Uniform Securities Act, other than anti-fraud statutes. Exemption means not being subject to the registration provisions of the Acts even though that person meets the definition. For example, a person defined as an investment advisor can be exempt from state registration requirements as an investment advisor because that person enjoys an exemption from state registration under federal law, such as in the case of a federal covered advisor. Relevant to the previous, a significant portion of the law, and the exam, deals with those who are either excluded from the definition or who are investment advisors, but exempt from registering as such. Let's begin with those who are excluded from the definition. Exclusions. Although the definition of an investment advisor is broad, certain exclusions apply. Under state law, the Uniform Securities Act, there are 7 primary exclusions from the definition of an investment advisor. Any bank and bank holding company, savings institution, or trust company. This exclusion is generally limited to U.S. banks and bank holding companies. The exclusion is unavailable to credit unions and investment advisor subsidiaries of banks or bank holding companies. Definition: Bank holding company. A holding company is organized to invest in and manage other corporations. Control can occur through the ownership of more than 50% of the voting rights or through the exercise of a dominant influence. It is sometimes referred to as the parent organization. A bank holding company is a holding company whose primary asset is a commercial bank. Most of the large U.S. banks today are owned by holding companies. Any lawyer, accountant, teacher, or engineer whose advice is solely incidental to the practice of his profession is excluded. This exclusion is not available to any of these who have established a separate advisory business. Also, the exclusion would not be available to any of these who holds himself out as offering investment advice. We like to refer to this as the LATE exclusion. Example. When referring to the LATE exclusion, it is important to understand the meaning of incidental. A lawyer advising clients to carefully invest a settlement from a legal case is not giving investment advice unless charging a separate fee for helping set up the portfolio. An accountant is not giving investment advice when suggesting to a wealthy client that investing in tax-exempt municipal bonds might be a wise idea, unless charging a separate fee to help select the bonds. 10 Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.IND 10 15 March 2019 10:57 and 49 seconds AM. Any broker-dealer whose performance of such services is solely incidental to the conduct of its business as a broker-dealer and who receives no special compensation, such as when offering RAP fee programs, is excluded. The exclusion also applies to registered representatives, agents, of broker-dealers. Definition: Broker-dealer. A person engaged in the business of executing securities transactions. This is covered in detail at Unit 3. Definition: RAP fee program. Any advisory program generally established by a broker-dealer, under which a specified fee or fees not based directly upon transactions in a client's account is charged for investment advisory services, which may include portfolio management or advice concerning the selection of other investment advisors, and the execution of client transactions. The exclusion from the definition of investment advisor available under both state and federal law to broker-dealers is not in effect for those offering RAP fee programs. The exam may ask about these programs this way. Which two of the following are services provided in a RAP fee program? The correct choice would be investment advisory and brokerage execution, transactions, for a single wrapped fee. Don't choose financial planning and recommendations. Take note. Special compensation for investment advice is compensation to the broker-dealer or salesperson in excess of that which he or she would be paid for providing a brokerage or dealer service alone. Consequently, special compensation exists where there is a clearly definable charge for investment advice. Publishers may qualify for an exclusion from the definition, but they must meet certain criteria. Excluded from the definition of investment advisor would be a publisher of any bona fide newspaper, news magazine, or business or financial publication of general and regular circulation. 2. To qualify for this exclusion, the publication must be 1. Of a general and impersonal nature, in that the advice provided is not adapted to any specific portfolio or any client's particular needs. 2. Bona fide, or genuine, in that it contains disinterested commentary and analysis as opposed to promotional material. And 3. Of general and regular circulation, in that it is not timed to specific market activity or events affecting, or having the ability to affect the securities industry. For example, newspapers of general circulation would be eligible for the exclusion. Test topic alert. An investment newsletter is being published for a subscription fee. Rather than being published on a regular basis, weekly, monthly, quarterly, and so forth, issues are released in response to market events. How do the laws view this publisher? If the publication is issued from time to time in response to episodic market events, the exclusion is lost. 2. Section 202, A, 11, D, of the Investment Advisors Act of 1940. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. 11. 65_LEM.INT 11 15 March 2019 10:57 and 49 seconds AM. Certain individuals who are employed by investment advisors, investment advisor representatives, described in detail in Unit 2, LA1, any person who is a federal covered advisor is excluded. Any other person the administrator specifies is excluded. The exclusions under the Investment Advisors Act of 1940 mirror the first four we listed for the Uniform Securities Act. In addition, there is a fifth exclusion under federal law: any person whose advice, analyses, or reports are related only to securities that are direct obligations of, or obligations guaranteed by, the United States. Take note. For purposes of the exclusion, under both state and federal law, the term bank does not include a savings and loan association or a foreign bank, but does include a savings institution. Because understanding these exclusions is so important, let's look at a few examples. Example 1. The Uniform Securities Act excludes certain persons from the definition of an investment advisor if their performance of advisory services is solely incidental to their professions. This exclusion would apply to all of the following except A. An accountant; B. An economist; C. An electrical engineer; D. A college professor teaching a course on economics. Answer: B. As long as the activity is incidental to the professional practice, and no separate fee for the advice is charged, the Act specifically excludes accountants, lawyers, any professional engineer, aeronautical, civil, mechanical, or others, and teachers. Economists are not included in this listing. Most economists are not teachers. 2. Which of the following would be excluded from the definition of investment advisor under the Uniform Securities Act? A. The publisher of a weekly magazine, sold on newsstands, that contains at least 5 stock recommendations per issue. B. A broker-dealer making a separate charge for investment advice. C. A civil damages attorney who advertises that she is available to assist clients in suggesting appropriate investments for their successful claim. D. A finance teacher at a local community college who offers weekend seminars on comprehensive financial planning at a very reasonable price. Answer: A. Publishers of general circulation newspapers and magazines are excluded from the definition of investment advisor, especially because the entire publication is devoted to impersonal investment advice. An important key here is that it is published regularly, not upon market. 12. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.Inc. 12 the 15th of March 2019 10:57 and 50 seconds AM. Events. A broker-dealer loses its exclusion the moment it offers advice for a separate charge, as does an attorney who holds herself out as offering investment advice. Normally, a teacher is excluded, but not when charging for advice as would appear to be the case here. On this examination, the term comprehensive, or total, financial planning always includes securities advice. Exemptions. When it comes to exemptions, state and federal laws have established rules whereby a person, although meeting the definition of an investment advisor, is not required to register as such. That person is considered to be exempt from registration. Because the state and federal exemptions are not as similar as the exclusions, let's take them separately, starting with the exemptions available under the Investment Advisors Act of 1940, Federal Law. Federal Law Exemptions. The Investment Advisors Act of 1940 exempts the following persons who, even though defined as investment advisors, are exempt from the registration requirements of the Act. Intrastate advisors, only within one state. Investment advisors, other than an investment advisor who acts as an investment advisor to any private fund, defined at 004, whose clients are residents of the state in which the advisor has its principal office and only place of business, and who do not give advice dealing with securities listed on any national exchange, example, New York Stock Exchange, are exempt. For example, an advisor would be exempted under this provision if all of its clients were Georgia residents, its only places of business were in Georgia, and it did not give advice on securities listed on any national exchange. Advisors to insurance companies. Advisors whose only clients are insurance companies are exempt. Test topic alert. Please be careful on this last one. The exam frequently asks if the exemption applies when the only clients are banks. As we'll learn shortly, that exemption applies under state law, but not under federal law. State law exemptions. In the same manner as the federal law, the Uniform Securities Act exempts from registration certain persons who, although they fall within the definition of an investment advisor, do not have to register as such in the state. Investment advisors exempt from registration with the state administrator are those who have no place of business in the state but are registered in another state, provided their only clients in the state are broker-dealers registered under the Act. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors 13. S65_LEM.Inc. 13 the 15th of March 2019 10:57 and 50 seconds AM. Other investment advisors. Institutional investors. Existing clients who are not residents but are temporarily in the state. Limited to 5 or fewer clients, other than those listed above, resident in the state during the preceding 12 months, called the de minimis exemption, or any others the administrator exempts by rule or order. Definitions. Institution. The term institution would include banks, trust companies, savings and loan associations, insurance companies, investment companies, example, mutual funds, employee benefit plans with assets of not less than $1 million, and governmental agencies or instrumentalities. Institutions are included in the term person, defined previously. The Act generally affords less protection to these investors owing to their supposed greater investment sophistication. Retail client. As you know, terminology is very important on this exam. A few questions use the term retail client instead of non-institutional client. Look for it and remember that retail clients need far more protection than institutional ones. If the question refers to an individual, that will always be a retail client. Take note. This exemption applies to investment advisors who are registered in at least one state, but have clients in another state where the IA does not maintain a place of business. Test topic alert. One of the previous bullet points refers to an exemption to those investment advisors who have no place of business in the state, but are licensed in another state where they have a place of business, and offer advice in the state only with persons in the state who are existing customers and who are not residents of the state but are just there temporarily. This is sometimes referred to as the snowbird exemption because it is frequently used to deal with existing clients who winter in warmer climates. The time limit defining temporary is not tested. Some folks spend 3 to 4 months staying warm, but if the client should change legal residence to that state, the investment advisor has 30 days to register in that state or discontinue doing business with that client, unless qualifying for the de minimis exemption. It is similar to the common experience of moving from one state to another. When you do that, you generally have 30 days to get new license tags for your car and a new driver's license. Test topic alert. Because these exemptions all apply when the investment advisor does not have a place of business in the state, it is relevant to understand that an investment advisor or one of its representatives who advertises to the public, in any way, the availability of meeting with prospective clients in a hotel, country club, seminar, or 14 Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.IND 14 the 15th of March 2019 10:57 and 50 seconds AM. Any other location in the state is considered to have a place of business in the state. However, an investment advisor or one of its representatives who contacts existing clients who happen to be in the state and notifies them that he will be passing through the state and will be available to meet with them in his hotel room is not considered to have a place of business in the state because the announcement is being made only to existing clients and not to the public. Example: an investment advisor registered in State A, with no business locations in any other state, has, over the preceding 12 months, directed investment advice to 5 individual investors residing in State B. Is the investment advisor required to register in State B? The answer is no. Registration is not required because the investment advisor does not have a place of business in State B and directs business to 5 or fewer individual residents of the state during the previous 12 months, de minimis exemption. If the firm had a place of business in State B, registration would be required in that state even if it had only one client. Also, registration would be required if business had been transacted with 6 or more individual residents, retail clients, of State B during the previous 12 months. What if the buyer gave investment advice to 6 banks, 6 insurance companies, and 6 other investment advisors instead of the individuals? Again, the answer would be no registration. As long as the investment advisor has no place of business in the state and limits its clientele to institutions, broker-dealers, large employee benefit plans, or other investment advisors, it qualifies for this exemption. Union LO4, identify the exempt reporting advisor and private fund advisor exemptions. We've just listed a number of exemptions under federal and then state law. Here is another one that applies to both with only a slight difference between them. Private fund advisors. Title 4 of the Dodd-Frank Act of 2010, known as the Private Fund Investment Advisors Registration Act of 2010, contains a comprehensive overhaul of the registration process for investment advisors. The bill provided for the following new exemptions from registration under the Advisors Act. An exemption for advisors solely to private funds with less than $150 million in assets under management, AUM, in the United States, without regard to the number or type of private funds, the private fund advisor exemption. An exemption for certain non-U.S. advisors with no place of business in the United States and minimal AUM, less than $25 million, attributable to U.S. clients and investors, the foreign private advisor exemption. An exemption for advisors solely to venture capital funds, the venture capital fund exemption. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors 15. S65_LEM.INT 15 the 15th of March 2019 10:57 and 50 seconds AM. Definition of a private fund. Although it is highly unlikely you will be tested on the technical definition, Section 402 of the Dodd-Frank Act defines a private fund as an issuer that would be an investment company, as defined in Section 3 of the Investment Company Act of 1940, but for Section 3(c)(1) or 3(c)(7) of that Act. In more straightforward terms, a 3(c)(1) issuer is one whose outstanding securities are beneficially owned by not more than 100 persons and which is not making and does not presently propose to make a public offering of its securities. With no more than 100 shareholders and no public offering, the term private fund seems quite logical. A 3(c)(7) issuer is one whose outstanding securities are owned exclusively by persons who, at the time of acquisition of such securities, are qualified purchasers, at least $5 million in investments for individuals and generally $25 million in investments for business entities, and which is not making and does not at that time propose to make a public offering of such securities. In this case, the lack of a public offering is logically private, and the fact that the invested wealth requirement limits the potential universe of investors is a factor as well. The point is, regardless of how it's defined, if one is an advisor solely to private funds, it is possible to qualify for an exemption from registration with the SEC. Well, what about state law? Their model rule closely parallels the federal exemption with two differences. Private fund advisor exemption under state law. NIEVES model rule for the registration exemption for investment advisors to private funds is almost identical to the federal exemption described previously. Here are the two differences that might be testable. If qualifying for the exemption as a 3(c)(1) issuer, no more than 100 investors, NIEVES model rule requires that all investors be qualified clients. That is, they must have either at least $1 million in assets managed by the investment advisor, or a net worth, excluding the value of the primary residence, of at least $2.1 million. The phrase value of primary residence means the fair market value of a person's primary residence, minus the amount of debt secured by the property up to its fair market value, net equity. Note that qualified for NASA is significantly less than qualified under federal law. Neither the private fund advisor nor any of its advisory affiliates are subject to the bad actor provisions. Those provisions disqualify anyone who has certain criminal convictions, generally felonies, certain SEC disciplinary orders, or suspension or expulsion from membership in a self-regulatory organization such as FINRA. Exemption for foreign private advisors. A foreign private advisor is defined in the Dodd-Frank Act as any investment advisor that has no place of business in the United States, has, in total, fewer than 15 clients and investors in the United States in private funds advised by the advisor. 16-Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.INF 16 the 15th of March 2019 10:57 and 50 seconds AM. Has aggregate AUM attributable to clients in the United States and investors in the United States in private funds advised by the advisor of less than $25 million, and does not hold itself out to the public in the United States as an investment advisor or act as an investment advisor to an investment company registered under the Investment Company Act of 1940. Exemption for investment advisors to venture capital funds. The rules define a venture capital fund as a private fund that has limited leverage, does not, except in certain limited circumstances, offer its investors redemption rights or other similar liquidity rights, represents itself as a venture capital fund to investors, and is not registered under the Investment Company Act of 1940. What really are venture capital funds? What is venture capital? You are probably familiar with the phrase, startup company. At one point in time, well-known firms like Google, Facebook and Netflix were young and in need of additional capital to expand and grow. Venture capitalists are investors who are willing to take a chance on a new venture, recognizing that there is a high potential for loss as well as potential for gain which can, in some cases, be very high. A venture capital fund is a pooled investment where venture capitalists invest their money and pay an advisor to select opportunities meeting their objectives. If these conditions are met, that investment advisor is exempt from registration under federal and state law. Take note. We will have more to say about the operations of private funds and venture capital funds in Part 3, Unit 14, LO5. Please note that these exemptions are granted on the basis of who you advise, not on what types of securities are the subject of your advice. Note also that exclusion means exclusion from a definition, whereas exemption means not subject to registration. All of the exemptions mentioned here involve investment advisors. It's just that they qualify for an exemption from registration under federal law. Example. 1. Who of the following would not qualify for an exemption from registration under the Investment Advisors Act of 1940? A. A person whose only advisory clients are insurance companies. B. A person whose only offices are in a single state, whose only clients are residents of that state, and who does not render advice on securities traded on a national exchange. C. A person who only gives advice to venture capital funds. D. An accountant whose advice is incidental to her accounting business and for which no separate fee is charged. Answer: D. This is tricky, as is the exam. The accountant is excluded from the definition. Therefore, there is no reason for her to be exempt. The other three choices are investment advisors who qualify for one of the exemptions described previously. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors 17. S65_LEM.INT 17 the 15th of March 2019 10:57 and 50 seconds AM. Union LO5. Describe the investment advisor registration process, required post-registration filings, and business activities. Unless an exemption is available, federal and state law make it unlawful for a person defined as an investment advisor to engage in advisory activity without registration. As we will learn, registration is done on either a federal or a state basis, never both. Once registered, there are a number of post-registration activities required, such as record-keeping, annual filings, and other reports. Registration requirements for investment advisors. At this point, we know who is an investment advisor, who is excluded from the definition and who, although defined as an investment advisor, is exempt from registration. If the person is not excluded and not exempt, then registration is required. In 1996, a major change to the registration requirements took place with the passage of the National Securities Markets Improvement Act, the NSMIA. Up until that time, investment advisors registered with both the federal agency, the SEC, and the appropriate states. However, the NSMIA bifurcated, split in two, those requirements by declaring that investment advisors would register with the SEC or the states, but not both. They did this by creating a new definition, Federal Covered Investment Advisor, sometimes just referred to as a covered advisor on the exam. What makes someone a Federal Covered Investment Advisor? In most cases, they are the larger firms and are registered with the SEC. The three most tested categories are those registered with the SEC because they are eligible, $100 million in assets under management, or required to register with the SEC because they meet the minimum threshold of assets under management, currently $110 million. Those under contract to manage an investment company registered under the Investment Company Act of 1940, example, a mutual fund, regardless of the amount of assets under management, and those not registered with the SEC because they are excluded from the definition of an investment advisor by the Investment Advisors Act of 1940. The most tested example of this case is the investment advisor whose advice is limited solely to securities issued by the U.S. government or one of its agencies. Take note. Because so much of this exam deals with interpreting the laws, it is sometimes necessary to review some legal concepts with you. For example, if a person is excluded from the definition of investment advisor under the Investment Advisors Act of 1940, the states, under the NSMIA, cannot define such person as an investment advisor because federal law excluded that person from the definition. In other words, if the separate states could define those persons who were excluded from the federal definition as investment advisors, the federal law would have no meaning. Dodd-Frank and assets under management. As stated previously, the NSMIA eliminated state registration requirements for federal covered advisors, largely based upon assets under management, AUM. Dodd-Frank has created 18 Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM. In dating 15 March 2019 10:57 and 51 seconds AM. Thresholds: 1 for the large advisor, 1 for the mid-size advisor, and, logically, 1 for the small advisor. Let's examine each of these, their requirements and their exceptions, if any. Large investment advisors. Large advisors, those advisors with at least $100 million or more in assets under management, are eligible for SEC registration. Once AUM reach $110 million, registration with the SEC is mandatory. Unless covered by one of the exemptions mentioned previously, all large IAS must register with the SEC. State registration is not required because the federal law preempts state registration. Small investment advisors. This category includes advisors with AUM of less than $25 million. Unless the investment advisor is an advisor to an investment company registered under the Investment Company Act of 1940, registration with the SEC is prohibited and, unless exempted under state rules, registration with the state is required. However, if the advisor would be required to register in 15 or more states, the prohibition is lifted, and registration with the SEC would be permitted instead. Mid-size advisors. This category includes those with AUM of at least $25 million but not $100 million. Generally, these advisors are prohibited from SEC registration and must register with the state. Just as with any other category, advisors to an investment company registered under the Investment Company Act of 1940 register with the SEC. That is true regardless of their size. A mid-sized firm can qualify for SEC registration several other ways. A mid-sized advisor is not prohibited from registering with the SEC. If the advisor is not required to be registered as an investment advisor with the securities administrator of the state in which it maintains its principal office and place of business. If registered, the advisor would not be subject to examination as an investment advisor by that securities administrator. If the advisor is required to register in 15 or more states, or if the advisor elects to take advantage of the buffer, described following. Other exceptions under Dodd-Frank. The SEC is permitted to grant exceptions to advisors from the prohibition on commission registration, including small and mid-sized advisors, if the application of the prohibition from registration would be unfair, a burden on interstate commerce, or otherwise inconsistent with the purposes of the Act. Under this authority, they have adopted several exemptions from the prohibition on registration with the SEC, including pension consultants, but only those with at least $200 million under control. The SEC picked that number to ensure that, to register with the SEC, if desired, the consultant's activities are significant enough to have an effect on national markets. Those mid-size advisors with at least $100 million in AUM, but less than $110 million in AUM who elect to register with the SEC rather than the states, this buffer will be described following. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors 19. S65_LEM.IND 19 the 15th of March 2019 10:57 and 51 seconds AM. Investment advisors expecting to be eligible for SEC registration within 120 days of filing the application for registration on the Form ADV, and Internet advisors. The $10 million and $20 million buffers. The numbers work like this. A state-registered advisor may, once it has AUM of at least $100 million, subject to certain of the exceptions previously mentioned, everyone needs at least $100 million to initiate registration with the SEC, may choose to remain state-registered or may register with the SEC. Once AUM reach $110 million, registration with the SEC is mandatory. They can no longer stay state-registered. That is the $10 million buffer. The SEC recognized that market conditions, or obtaining or losing clients, can cause AUM to fluctuate, so they established a $20 million buffer to keep advisors from having to switch back and forth. Once registered with the SEC, an investment advisor need not withdraw its SEC registration unless it has less than $90 million of AUM. Having become SEC registered, the IA can remain so as long as AUM remain at or above the $90 million level. Likewise, those investment advisors registered at the state level can choose to remain there until they reach the $110 million level. This buffer is designed to avoid the expense and hassle involved in potentially annual changes to where the investment advisor is registered. Time for measuring AUM. These numbers are based on the AUM reported on the IA's annual updating amendment. The effect of this is that a federal covered advisor's AUM could drop below $90 million during the year without triggering the need to change to state registration, just as long as the annual update showed at least the minimum $90 million required. Of course, the same would be true of a state-registered IA whose AUM peaked above $110 million during the year but then fell at the time of the update. If, at the time of filing the annual updating amendment to the Form ADV by an SEC-registered IA, the reported AUM is less than $90 million, it is necessary for the investment advisor to withdraw its SEC registration and register with the appropriate states within 180 days. On the other hand, if a state-registered advisor's reported AUM exceed $110 million, registration with the SEC must take place within 90 days. Take note. The buffer works because the measurement is made only once per year, at the time of the filing of the firm's annual updating amendment. Remember these three relevant times. 1. When a state-registered IA reports AUM at $110 million or more on the annual updating amendment, the IA must withdraw from the states and register with the SEC within 90 days. 2. When a new investment advisor files for registration, if that IA believes that it will have at least $100 million in AUM within the first 120 days, it is eligible to register with the SEC, even if their AUM is way below that on day one. This is very common when a large BD decides to open an IA and knows that they will have billions of dollars in a short time. 3. When an SEC-registered IA reports less than $90 million in AUM on the annual updating amendment, the IA must withdraw its registration with the SEC and register in the appropriate states within 180 days. 20 Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.IND 20 the 15th of March 2019 10:57 and 51 seconds AM. Why is the time allowed in number 3 twice as long as in number 1? Because it takes much less time to register with one agency, the SEC, than to register potentially with a number of states. Take note as a general rule, the SEC or federal rules involve bigger numbers than the state rules, that is, large investment advisors must register with the SEC, whereas small investment advisors must register with the state. $0 million. $100 million. Advisor managing. $25 million. $110 million or more large SEC registration. $25 but not $100 million mid-size state registration. $100 million but not $110 million SEC or state registration. Less than $25 million small advisor state registration. Registration process. How does registration take place? With only a few differences, the procedures for registering as an investment advisor are the same, whether registering with the SEC or with the states. Those differences will be pointed out as we go along. To register with the State Securities Administrator, a person must submit an application, provide a consent to service of process, pay filing fees, post a bond, if required by the administrator, and take and pass an examination if required by the administrator. The examination may be written, oral, or both. Registration is accomplished using the Form ADV. The Form ADV consists of Part 1A and Part 1B, and Part 2A, and Part 2B. Investment advisors use Form ADV to register with the Securities and Exchange Commission, register with one or more state securities authorities, or amend those registrations. Filing in almost all cases is done through the Investment Advisor Registration Depository. IARD. The IARD is an electronic filing system that facilitates investment advisor registration, regulatory review, and the public disclosure information of investment advisor firms. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal-covered advisors 21. S65_LEM.IND 21 15 March 2019 10:57 and 51 seconds AM. How is Form ADV organized? Form ADV contains 4 parts. Part 1A asks a number of questions about the investment advisor, its business practices, the persons who own and control the firm, and the persons who provide investment advice on behalf of the firm. All advisors registering with the SEC or any of the state securities authorities must complete Part 1A. Part 1A also contains several supplemental schedules. These include Schedule A, which asks for information about the direct owners and executive officers, control persons, and Disclosure Reporting Pages, or DRPs, which are schedules that ask for details about disciplinary events involving the advisor or advisory affiliates. Part 1B asks additional questions required by state securities authorities. Investment advisors applying for registration or who are registered only with the SEC do not have to complete Part 1B. Part 2A requires advisors to create narrative brochures containing information about the advisory firm. The requirements in Part 2A apply to all investment advisors registered with or applying for registration with the SEC or the states. Part 2B requires advisors to create brochure supplements containing information about certain supervised persons. The requirements in Part 2B apply to all investment advisors registered with or applying for registration with the SEC or the states. It may help you remember that the A in Part 2A tells us that part is for the advisor and the B in Part 2 is about the bodies, the people, who work there. We will cover the brochures and brochure supplements in greater detail later in Unit 6. Test Topic Alert. Control means the power, directly or indirectly, to direct the management or policies of an investment advisor, whether through ownership of securities, by contract, or otherwise. Under the Investment Advisors Act of 1940 as well as NASAA's Model Rule, each of the firm's officers, partners, or directors exercising executive responsibility, or persons having similar status or functions, is presumed to control the firm. A person is presumed to control an IA organized as a corporation if the person directly or indirectly has the right to vote 25% or more of a class of the corporation's voting securities. A person is presumed to control one that is a partnership if the person has the right to receive upon dissolution, or has contributed 25% or more of the capital of the partnership. Please note that this is a different percentage from the definition of control person under the Securities Exchange Act of 1934, Unit 7, where having more than 10% of the voting power makes one a control person. Remember that control person is defined three different ways. The Exchange Act requires more than 10%, the Investment Company Act, Unit 14, requires more than 25%, and the Advisors Act and the USA require 25% or more. 22 Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.IND 22 the 15th of March 2019 10:57 and 52 seconds AM. Form ADV Part 1 contains information about the IA, including location of principal office, location of books and records, if not at the principal office, form of business organization, sole proprietorship, partnership, corporation, LLC, and so forth, method of business, other business activities, broker-dealer, registered representative, agent, of a BD, maintaining custody of customer assets or exercising discretion, details relating to all control persons, officers, directors, partners, etc., disciplinary history, and for state-registered IAS, states in which the IA intends to or is already registered. Part 1B asks additional questions required by state securities authorities. Federal covered advisors do not complete the Part 1B. Part 2A is known as the Investment Advisors Brochure and tends to focus on customer-related information, such as compensation arrangements, fees, commissions, hourly charge. Types of clients, individuals, institutions, pension plans. Type of investments, equities, corporate debt, municipal securities, U.S. Treasuries, investment companies, types of strategies employed, buy and hold, value, growth, methods of analysis used, technical, fundamental, educational and business background of those who render advice, and an audited balance sheet if a federal or state-registered advisor requires or solicits substantial prepayment of fees, defined shortly, or if a state-registered advisor maintains custody. Discussed at Unit 7. The brochure is arranged in a narrative form using plain English. Part 2B requires advisors to create brochure supplements containing information about certain supervised persons. Together, Part 2A and Part 2B are delivered to the client as described later in this unit. State-registered advisors file both Part 1 and Part 2 with the administrator of each state in which they are registering. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors 23. S65_LEM.IND 23 the 15th of March 2019 10:57 and 52 seconds AM. Example. 1. If a prospective client wanted to know what type of investment strategies are employed by an investment advisor, that information would be found in the Advisors Act, Form ADV Part 1AB, Form ADV Part 1BC, Form ADV Part 2AD, Form ADV Part 2B. Answer. C. The Form ADV Part 2A contains information of most use to clients, such as the type of strategies employed by the advisor. Part 1A contains information needed by the regulators. Part 1B is only for state-registered IAS. Part 2B contains information dealing with those individuals in the firm who manage accounts. Test topic alert. Although there are no minimum educational or experience requirements, there is a specific area on the Form ADV Part 2 where state-registered advisors must identify each of the principal executive officers and management persons, and describe their formal education and business background. If this information has been supplied elsewhere in the Form ADV, it is not necessary to repeat it in response to this question. Updating the Form ADV. The Form ADV must be updated each year by filing an annual updating amendment within 90 days after the end of the advisor's fiscal year. This annual updating amendment is used to update the responses to all items on the ADV. Of critical importance is the verification of AUM, ensuring that the advisor is eligible to continue being registered with the SEC. One of the requirements relating to the brochure described in Part 2 is that submission must be made of a summary of material changes either in the brochure, cover page or the page immediately thereafter, or as an exhibit to the brochure. Amendments for material changes. In addition to the annual updating amendment, the IA must amend the Form ADV by filing additional amendments promptly if information relating to any of the following changes or becomes inaccurate in any way. Change of the registrant's name, change in the principal business location, change in the location of books and records, if they are kept somewhere other than at the principal location, change to the contact person preparing the form, change in organizational structure, such as from partnership to corporation and so on. Information provided in the brochure becomes materially inaccurate, change to any of the questions regarding disciplinary actions, change in policy regarding custody of the customer funds and or securities. 24 Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.IND 20 for the 15th of March 2019, 10:57 and 52 seconds AM. Fees. In addition to the initial registration, there is a requirement for annual renewal. There are fees for the initial filing and renewals. If an investment advisor changes its form of business organization, example, from a sole proprietorship to a corporation, a new ADV, but no fees, would be required. Test topic: alert successor firm. Under both federal and state law, a successor firm registers by filing a new application and, in the case of the SEC, paying the appropriate fee and, under the USA, without additional fee. Please note the difference: one case involves a fee, the other does not. Notice filing. While on the topic of fees, it is important to recognize what happened to state revenues after the passage of the NSMIA. Prior to that time, investment advisors registered on both levels, and that meant, in many cases, registering with 20, 30 or more states, with each state collecting a nice fee. When state lobbyists realized that the NSMIA, by excluding federal covered advisors from the definition, meant that those advisors would no longer have to register, they implored Congress to put some condition into the act that would help recover some of that lost revenue. That is how notice filing came about. Instead of registering with the states, covered advisors pay state filing fees and give notice to the administrator. The procedure followed is called notice filing. As part of the notice filing, the administrator can require a federal covered advisor to file a copy of whatever has been filed with the SEC, and, of course, pay a filing fee. Test topic: alert. Federal covered advisors must make a notice filing with the state if they have a place of business in the state or of 6 or more clients in that state in a 12-month period, regardless of place of business. If a federal covered advisor only deals with institutions, other IAS, other BDS, and so forth, notice filing is not required. This is a similar concept to the USA not requiring registration of state-registered advisors who have no place of business in the state and deal with this same group of clients. We have not heard of this ever being asked on the exam, but you never know what NASA has up their sleeve. Provide a consent to service of process. New applicants for registration must provide the administrator of every state in which they intend to register with a consent to service of process. The consent to service of process appoints the administrator as the applicant's attorney to receive and process non-criminal securities-related complaints against the applicant. Under the consent to service of process, all legal documents, example, subpoenas or warrants, received by the administrator have the same legal effect as if they had been served personally on the applicant. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors 25. S65_LEM.IND 25 the 15th of March 2019 10:57 and 52 seconds AM. Take note. The consent to service of process is submitted with the initial application and remains in force permanently. It does not need to be supplied with each renewal of a registration. Effective date of registration and renewals. A Assuming there are no irregularities in the application, registration with the SEC takes effect on the 45th day after filing of a complete application and, as with all securities professionals, at noon of the 30th day in the case of state-registered investment advisors. Test topic alert. One of the most common questions asked on the exam is the renewal date for the state registration of investment advisors and the other securities professionals, investment advisor representatives, IAR, broker-dealers, and agents. That renewal date is December 31st. One of the tricks the exam likes to play is asking about a person who registers in November. When does that registration come up for renewal? Well, even if it is only a month or so later, every registration of a securities professional comes up for renewal on the next December 31st, so your first year is always a short one. Definition: agent. The USA defines an agent as any individual who represents a broker-dealer, legal entity, or an issuer, legal entity, in effecting, or attempting to effect, transactions in securities for their clients. You will learn more about that in Unit 3 LO3. Test topic alert. Although the registration normally takes 30 days, the administrator has the power to shorten that period, in effect permitting a rush order. Test topic alert. Although successful completion of the Series 65 examination may satisfy a portion of the requirements of a particular state, it does not convey the right to transact business before being granted a license or registration by that state. Example: while registration as an IAR is pending, the individual may not take part in any activity that would require registration. Clerical work, filing customer records, or assisting internally with research would be permitted. Just as the exam may ask about registering, it may ask about leaving the business. 26 Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.IND 26 of 15th of March 2019 10:57 and 52 seconds AM. Form ADVW. If an advisor no longer desires to engage in the business, application to withdraw registration is accomplished by filing Form ADVW. Form ADVW must be filed to withdraw the registration voluntarily. As is typical, the timing is different under federal and state law. For covered advisors, the withdrawal takes 60 days. In the case of a state-registered advisor, it is 30 days after filing. A testable point is that the administrator retains jurisdiction over the formal registrant for a period of 1 year. In Unit 5, we'll discuss the conditions under which a registration may be cancelled by the administrator. Exempt reporting advisors, ERAs. As described previously, there is an exemption from registration for certain private funds and venture capital funds. However, even though exempt from registration, if designated as ERAs, they are required to complete and electronically file reports using the IRD system on certain items set forth in Form ADV, which will be made publicly available on the SEC's website. Test topic alert. Exempt reporting advisors, ERAs, file an abbreviated Form ADV Part 1. They don't answer all of the questions, but do not have to prepare a Form ADV Part 2. Financial requirements for registration as an investment advisor. Under the Investment Advisors Act of 1940, no specific financial requirements, such as a minimum net worth, are spelled out. However, as we will see, there are financial disclosures that must be made to clients under certain conditions. Under the Uniform Securities Act, the administrator may, by rule or order, establish minimum financial requirements for an investment advisor registered in the state. Those will be discussed shortly. Substantial prepayment of fees. Both state and federal law offer extra protection to those clients of investment advisors who have made substantial advance payment of fees for services to be rendered in the future. The term used is substantial prepayment of fees. In the case of a federal covered advisor, It is considered substantial if the IA collects prepayments of more than $1,200 per client, 6 months or more in advance. Under the NASA model rule, it is more than $500, and again, 6 months or more in advance. Test topic alert. When a state-registered investment advisor accepts prepayments of fees of more than $500 for a contract period of 6 months or more, it is known as a substantial prepayment. However, under the Investment Advisors Act of 1940, it does not become a substantial prepayment until it exceeds $1,200. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors 27. S65_LEM.IND 27 the 15th of March 2019 10:57 and 52 seconds AM. This might appear on your exam as example. 1. Which of the following would an administrator consider to be a substantial prepayment of fees? A. $500 covering the next 6 months. B. $800 covering the entire contract year. C. $800 covering the next calendar quarter. D. $5,000 covering the next month. Answer. B. NASA, state law, defines a substantial prepayment of fees to be more than $500, 6 or more months in advance. While $800 and $5,000 are certainly more than $500, they cover a shorter period than 6 months. Balance sheet requirement for federal covered advisors. Any federal covered investment advisor whose agreement requires substantial prepayment of fees, as previously defined, from clients, must include a balance sheet with the advisor's ADV Part 2A for the advisor's most recent fiscal year. The balance sheet must be prepared and audited by an independent public accountant. Balance sheet requirements for state-registered advisors. An audited balance sheet must be included with the ADV Part 2A for any state-registered investment advisor whose agreement requires substantial prepayment of fees, as defined previously, from clients. In addition, even without the fees, those who maintain custody of client funds and/or securities, covered at Unit 7, must include an audited balance sheet with their ADV Part 2A for their most recent fiscal year with the same requirements. The audited balance sheet is also required when the custodian is a related, affiliated, broker-dealer. Furthermore, state-registered advisors who exercise discretionary authority over client accounts but do not maintain custody must file with the administrator within 90 days of the end of the advisor's fiscal year a balance sheet, but this one does not have to be audited. Disclosure of financial impairment. Any investment advisor that has discretionary authority or custody of client funds or securities, or requires or solicits substantial prepayment of fees, must disclose any financial condition that is reasonably likely to impair its ability to meet contractual commitments to its clients. As an example, the SEC has indicated that disclosure may be required of any arbitration award sufficiently large that payment of it would create such a financial condition. Here is the way it is stated in the Form ADV Part 2. If you have discretionary authority or custody of client funds or securities, or you require or solicit prepayment of more than $1,200 in fees per client, 6 months or more in advance, you must disclose any financial condition that is reasonably likely to impair your ability to meet contractual commitments to clients. 3. Form ADV Part 2 Instructions, Item 18B. 28 Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.IND 28 the 15th of March 2019 10:57 and 53 seconds AM. Test topic alert. The administrator may require an advisor who has custody of client funds or securities or has discretion over a client's account to post a surety bond or maintain a minimum net worth. Usually, the requirement is higher for custody than for discretion. Typically, the net worth required of investment advisors with discretionary authority is $10,000 and that for those taking custody is $35,000. If the advisor is using a surety bond instead, the requirement in either case is $35,000. An advisor who does not exercise discretion and does not maintain custody, but does accept prepayment of fees of more than $500, 6 or more months in advance, must maintain a positive net worth at all times. Definition: surety bond. Usually issued by an insurance company, the surety, who guarantees payment of a specified sum to an injured party, either the client or the administrator, when the securities professional causes damages by his actions or fails to perform. Test topic alert. Because the USA is only a template, some states have higher net worth or bonding requirements. The exam may want you to know that if an IA meets the net worth or surety bonding requirements of the state where its principal office is located, that is sufficient in any other state in which it may be registered. Definition: principal office. We've used this term several times and it is an important one to know. Both state and federal law define this as the executive office of the investment advisor from which the officers, partners, or managers of the investment advisor direct, control, and coordinate the activities of the investment advisor. Example: 1. Manning Money Managers, MMM, has its principal office in State A and is also registered in States B, C, and D. MMM exercises discretion in client accounts. As a result, MMM would have to meet the net worth or bonding requirements of A. The SEC, B. State A, C. The state with the highest requirement, D. Each state. Answer: B. The state-registered investment advisor need only meet the financial requirements of the state in which its principal office is located. SEC requirements are meaningless here because this is a state-registered firm. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors 29. S65_LEM.INV 29 the 15th of March 2019 10:57 and 53 seconds AM. Test topic alert. One of the effects of the NSMIA is to limit the powers of an administrator over a federal covered advisor. Section 222 of the Investment Advisors Act of 1940 states that when it comes to federal covered advisors, any financial or bonding requirements, as well as rules relating to record keeping, are solely under federal jurisdiction. Test topic alert. The proper term to use when referring to the financial requirements of an investment advisor is net worth, while for broker-dealers it is net capital. However, we have heard from a number of students that NASA might be using net capital where they should be using net worth in questions about IAS. So, if you want to get the question right, answer it the way they give it to you. You will see several examples of this in our practice questions. Failure to maintain minimum net worth. NISAA's model rule specifies the action to be taken by a registered investment advisor whose net worth falls below the required minimum. By the close of business on the next business day, the advisor must notify the administrator that the investment advisor's net worth is less than the minimum required. After sending that notice, the advisor must file a financial report with the administrator by the close of business on the next business day. One more item that must be included in the report is the number of client accounts. When the advisor's net worth is below the minimum requirement, the advisor must obtain a bond in an amount of the net worth deficiency rounded up to the nearest $5,000. Example: a state-registered investment advisor discovers on Monday that its net worth is below the minimum requirement. No later than the close of business on Tuesday, notice must be sent to the administrator of the state in which the investment advisor has its principal office. Then, no later than the close of business on Wednesday, the investment advisor must file a detailed report with the administrator of its financial condition. Included in the report must be a statement as to the number of client accounts. Example: an investment investment advisor who maintains custody of customer funds and securities discovers that its net worth is only $23,000. Even though the advisor only needs a net worth of $35,000, this would require immediate surety bonding in the amount of $15,000 because it must be rounded up to the nearest $5,000. Computing net worth. At Part 2, Unit 9, LO1, we'll learn about computing net worth from a corporate balance sheet. For NASA purposes, the term net worth is the excess of assets over liabilities, assets. 30 Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.INT 30 the 15th of March 2019 10:57 and 53 seconds AM. Minus liabilities. However, NASA does not permit the investment advisor to include the following as assets: goodwill and all other assets of an intangible nature, home furnishings, automobiles, and any other personal items not readily marketable in the case of an individual. Advances or loans to stockholders and officers in the case of a corporation. Advances or loans to partners in the case of a partnership. However, furniture used in the office, such as a sofa in the reception room, or bookcases in the company research library, are considered assets for the purpose of the computation. Books and records required by federal and state law. The Uniform Securities Act virtually duplicates the first 12 items of the record-keeping requirements of the Investment Advisors Act of 1940 listed following. The major exception is that on the 11th bullet, a copy of each notice, NISAA's model rule requires a copy when the material is distributed to 2 or more persons, other than persons connected with the investment advisor, not 10 or more, as is the case under federal law. Unless the investment advisor is exempt from registration, the SEC and the states require investment advisors to maintain the following books and records: a journal, including cash receipts and disbursement records; general and auxiliary ledgers reflecting asset, liability, reserve, capital, income, and expense accounts; a memorandum of each order given by the advisor for the purchase or sale of any security, or any instruction received by the advisor from the client concerning the purchase, sale, receipt, or delivery of a security, and of any modification or cancellation of any such order or instruction. All checkbooks, bank statements, cancelled checks, and cash reconciliations. All bills or statements, or copies thereof, paid or unpaid. All trial balances, financial statements, and internal audit working papers. Originals of all written communications received and copies of all written communications sent by the advisor related to any recommendation or advice given or proposed to be given, any receipt, disbursement, or delivery of funds or securities, or the placing or execution of any order to purchase or sell any security, provided, however, that if the investment advisor sends any notice, circular, or other advertisement offering any report, analysis, publication, or other investment advisory service to more than 10 persons, the investment advisor shall not be required to keep a record of the names and addresses of the persons to whom it was sent, except that if the notice, circular, or advertisement is distributed to persons named on any list, the investment advisor shall retain with the copy of the notice, circular, or advertisement, a memorandum describing the list and its source. A record of all accounts in which the advisor is vested with any discretionary power with respect to the funds, securities, or transactions of any client. All powers of attorney and other evidences of the granting of any discretionary authority by any client to the advisor, or copies thereof. All written agreements, or copies thereof, entered into by the advisor with a client or otherwise relating to its investment advisory business. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors 31. S65_LEM.INT 31 the 15th of March 2019 10:57 and 53 seconds AM. A file containing a copy of each notice, circular, advertisement, newspaper article, investment letter, bulletin, or other communication, including by electronic media, email, that the investment advisor circulates or distributes, directly or indirectly, to 10 or more persons, other than persons connected with the investment advisor, if the item, including communications by electronic media, recommends the purchase or sale of a specific security and does not state the reasons for the recommendation. The advisor must prepare a memorandum indicating the reasons for that recommendation. A file containing a copy of all written communications received or sent regarding any litigation involving the investment advisor or any investment advisor representative or employee, and regarding any written customer or client complaint. A file containing a copy of each document that pertains to the registrant or its investment advisor representatives. That file should contain, but is not limited to, all applications, amendments, renewal filings, and correspondence. With certain exceptions, a record of all securities transactions in which an investment advisor or any advisory representative has, or by reason of such transaction acquires, any direct or beneficial ownership. In practice, the record-keeping rule has served as a deterrent to the practice of scalping because it requires all advisory representatives to report all of their security transactions to their affiliated advisory firms on a regular basis. These reports are subject to SEC examination. Scalping is the practice whereby an investment advisor, before the dissemination of a securities recommendation, trades on the anticipated short-run market activity that may result from the recommendation. Time period for maintenance of records. The Investment Advisors Act of 1940, as well as the NASA Model Rule on Record-Keeping Requirements for Investment Advisors, requires that an investment advisor's books and records be maintained in a readily accessible place for 5 years. The 5-year period will run from the end of the fiscal year during which the last entry was made on the record. During the first 2 years of the 5-year period, the rule requires that the records be maintained in the principal office of the advisor. However, after this initial 2-year period, the records may be preserved in electronic or microfilm format or any other form of data storage in compliance with the Act. Even though the record-keeping requirements are almost identical, it is important to remember for the test that federal covered advisors only comply with the SEC requirements while state-registered advisors need only meet the requirements of the state where their principal office is located. The NASA Model Rule also states that partnership articles and any amendments thereto, articles of incorporation, charters, minute books, and stock certificate books of the investment advisor and of any predecessor must be maintained in the principal office of the investment advisor and preserved until at least 3 years after termination of the enterprise. Test Topic Alert. A few pages ago, we gave you a test topic alert that emphasized that as long as state-registered investment advisors met the net worth or surety bond requirements of their home state, that was sufficient for any state in which they are. 32 Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.INT 32 the 15th of March 2019 10:57 and 53 seconds AM. Registered. The same is true regarding record-keeping requirements, and the proof is in the following statement copied from the Form ADV. 2. State-registered investment advisor affidavit. If you are subject to state regulation, by signing this Form ADV, you represent that you are in compliance with the registration requirements of the state in which you maintain your principal place of business and are in compliance with the bonding, capital, and record-keeping requirements of that state. Storage requirements. The records required to be maintained and preserved may be maintained and preserved for the required time by an investment advisor on paper or hard copy form, as those records are kept in their original form, micrographic media, including microfilm, microfiche, or any similar medium, or electronic storage media, including any digital, computer disk, storage medium or system, as long as the investment advisor establishes and maintains procedures to maintain and preserve the records. so as to reasonably safeguard them from loss, alteration, or destruction. To limit access to the records to properly authorized personnel and the administrator, and to reasonably ensure that any reproduction of a non-electronic original record on electronic storage media is complete, true, and legible when retrieved. In all cases, the investment advisor must arrange and index the records in a way that permits easy location, access, and retrieval of any particular record and provide the administrator with the means to access, view, and print the records. Here are a couple of examples for you. Example 1. Under the Investment Advisors Act of 1940, all of the following are true regarding advisor record-keeping except A. The IA must keep records of transactions made for its own account as well as the account of investment advisor representatives to lessen the likelihood of scalping. B. Computer-generated records may be stored in that format. C. Client account records must be maintained, including a list of recommendations made. D. Records must be maintained for a period of 2 years from the end of the fiscal year in which the last entry was made. Answer: D. This is the exception because the records must be kept for 5 years. Nothing in the question asked about the 2-year requirement in the office. The 5-year requirement is that records be easily accessible whether in the office or not. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal-covered advisors. 33. S65_LEM.INT 33 the 15th of March 2019 10:57 and 53 seconds AM. 2. An investment advisor registered in State G is obligated to maintain certain books and records as specified by the Uniform Securities Act. Which of the following statements regarding advisor record-keeping is not true? A. Records originally created on computer may be stored in electronic media. B. Records are subject to surprise audits by the State G administrator. C. Written records may be reduced to microfilm. D. Records must be kept for 6 years. Answer: D. Records of an investment advisor must be maintained for 5 years. Records are subject to surprise audits by the state administrator. Written records may be reduced to microfilm, and records originally created on a company's computer may be stored in electronic media. Test topic alert. You will need to remember that the record retention requirement for investment advisors is 5 years from the end of the year in which the record was originally generated. Supervisory requirements. Union LO6 recognized that investment advisor representatives must be adequately supervised. Each registered investment advisor must adopt and implement written policies and procedures designed to prevent violation of the federal and state securities laws, review those policies and procedures annually for their adequacy and the effectiveness of their implementation, and designate a Chief Compliance Officer, CCO, to be responsible for administering the policies and procedures. An advisor's CCO should be competent and knowledgeable regarding the Advisors Act and the USA and should be empowered with full responsibility and authority to develop and enforce appropriate policies and procedures for the firm. Thus, the compliance officer should have a position of sufficient seniority and authority within the organization to compel others to adhere to the compliance policies and procedures. In fact, the CCO's identity must be disclosed on the Form ADV. The role of the CCO is particularly important when it comes to ensuring supervision of those individuals referred to as supervised persons. Definition: supervised person. Any of the IAS officers, partners, directors, or other persons occupying a similar status or performing similar functions, or employees, or any other person who provides investment advice on the investment advisor's behalf and is subject to its supervision or control. The most common example is the investment advisor representative, defined in Unit 2. Although many supervised persons fall within the definition of investment advisor, they meet the 3-prong test. The SEC and the states do not require those individuals to register as investment advisors with the regulators. Instead, the advisory firm must register. The advisor's registration covers its employees and other persons under its control, provided that 34 Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors. S65_LEM.INT 30 for the 15th of March 2019 10:57 and 54 seconds AM. Their advisory activities are undertaken on the investment advisor's behalf. However, in most cases, these individuals must register as investment advisor representatives and come under the advisor's supervisory jurisdiction. This is particularly true in the case of financial planners who have elected to operate as independent contractors, not employees of investment advisory firms. Regardless, they are required to be registered as investment advisor representatives of the firm and must be placed under the same level of supervisory scrutiny as employees. Their business cards may contain the name of their separate planning entity, but must also disclose the name of the entity registered as the investment advisor. Unit 1. Unit 1 Regulation of Investment Advisors, including state-registered and federal covered advisors 35. S65_LEM.INT 35 the 15th of March 2019 10:57 and 54 seconds AM. S65_LEM.INT 36 the 15th of March 2019 10:57 and 54 seconds AM. Learning objectives. When you have completed this unit, you will be able to accomplish the following. U2LO1. Define investment advisor representative. U2LO2. Identify exclusions and exemptions under the Investment Advisors Act of 1940 and the Uniform Securities Act. U2LO3. Describe the investment advisor representative registration requirements and process, post-registration filings, and business activities. Introduction. In Unit 1, we defined an investment advisor, determined who is excluded from the definition or exempt from registration and, if required to register, with whom and how. In this unit, we will cover those individuals who represent investment advisors, investment advisor representatives. One important regulatory note is that, unlike investment advisors who register either on a federal or a state level, registration requirements of representatives only comes under the jurisdiction of the states. That is why this is a NASA exam rather than one sponsored by FINRA or the SEC. The exam will contain 4 questions on this unit. Investment advisor representatives. U2LO1. Define investment advisor representative. Investment advisor representative, IAR, means any partner, officer, director, or an individual occupying a similar status or performing similar functions, or other individual employed by. 2. Unit. Regulation of investment. Advisor representatives. 37. S65_LEM.INT 37 the 15th of March 2019 10:57 and 54 seconds AM. Or associated with an investment advisor and is registered or required to be registered under the Uniform Securities Act. Remember, IARs only register with the states. An individual meets the definition of an IAR by doing any of the following. Makes any recommendations or otherwise renders advice regarding securities. Manages accounts or portfolios of clients. Determines which recommendation or advice regarding securities should be given. Solicits, offers, or negotiates for the sale of or sells investment advisory services. Supervises employees who perform any of the foregoing. Example. An individual employed by an investment advisor who manages investment portfolios for clients is considered an investment advisor representative. So is the individual who supervises that person. Under state law, there is no distinct registration for supervisory persons as there is under FINRA's rules for broker-dealers. Even the CEO is registered as an IAR. Take note. The use of the term individual here is important. Only an individual, or a natural person, can be an investment advisor representative. The investment advisory firm is the legal person, entity, that the IAR, natural person, represents in performing the functions listed above. Take note. An individual may act as both an investment advisor and an investment advisor representative. This is typically the case when the business is organized as a sole proprietorship. However, an individual who acts solely as an investment advisor representative is excluded from the definition of investment advisor. IAR exclusions and exemptions. U2LO2. Identify exclusions and exemptions under the Investment Advisors Act of 1940 and the Uniform Securities Act. Just as with investment advisors, the laws provide for exclusions for the definition and exemptions for those who are defined as IARs. Exclusions from the definition of investment advisor. Representative. Certain employees of investment advisory firms are excluded from the term investment advisor representative, provided their activities are confined to clerical or administrative duties or those activities that are solely incidental to the investment advisory services offered, such as mailing out a research report to an advisory client when directed by an IAR. Should the investment advisory employee step over the line, as the saying goes, and perform any activity that makes one an IAR, the employee would then have to register as an investment advisor representative. 38 Unit 2 Regulation of Investment Advisor Representatives. S65_LEM.INC 38 the 15th of March 2019 10:57 and 54 seconds AM. In addition, an individual is not an investment advisor representative if the person does not on a regular basis solicit, meet with, or otherwise communicate with clients of the investment advisor or provides only impersonal investment advice. Let's define that last term because you're going to see it a number of times in this course. Impersonal investment advice means investment advisory services provided by means of written material or oral statements that do not purport to meet the objectives or needs of specific individuals or accounts. Example. 1. Which of the following individuals would be defined as an investment advisor representative? A. Melinda, one of the firm's research analysts, who has no contact with public clients. B. Johnny, an employee who makes cold call soliciting for new advisory clients. C. Mel, who prepares client account statements. D. Jane, who is the firm's VP of HR services. Answer. B. One of the functions making a supervised person an IAR is soliciting for new business. Research personnel are not considered IARs unless they have client relationships. Mel's job is purely clerical and, even though Jane is a vice president, the HR department is far removed from anything to do with giving investment advice. Exemptions from registration as an investment advisor. Representative. There are 3 different exemptions available for those defined as IARs. 2 of those are for those who represent state-registered IAS and the other for those who represent federal-covered IAS. If the individual represents a state-registered advisor, there is a de minimis exemption. Just as is the case with investment advisors, if an IAR does not maintain a place of business in the state and, during the preceding 12-month period has had no more than 5 retail clients, registration in the state is not required. The previously mentioned snowbird exemption also applies to these IARs. If the individual represents a covered investment advisor, there is a special exemption under Section 203A of the 1940 Act. Keeping it simple, it states that for those performing as IARs for federal covered advisors, IAR registration is required only in those states where that individual has a place of business. Place of business of an investment advisor representative means A. An office at which the investment advisor representative regularly provides investment advisory services, solicits, meets with, or otherwise communicates with clients, and B. Any other location that is held out to the general public as a location at which the investment advisor representative provides investment advisory services, solicits, meets with, or otherwise communicates with clients. Let's look at some examples. Unit 2. Unit 2 Regulation of Investment Advisor Representatives 39. S65_LEM.INT 39 the 15th of March 2019 10:57 and 54 seconds AM. Example. 1. Under the Uniform Securities Act, which of the following is not required to register as an investment advisor representative? A. The director of a state-registered investment advisory firm who determines specific recommendations for clients. B. An associate in an SEC-registered investment advisory firm who has a place of business in the state and manages the account of only one individual client. C. A clerk employed by a state-registered investment advisory firm. D. A vice president of a state-registered investment advisory firm who supervises employees who solicit clients for the firm. Answer. C. Clerical and ministerial, administrative, personnel are specifically excluded from the definition of investment advisor representative. Specifically included in the definition are directors, officers, partners, associates, and employees of state-registered advisors who carry out investment advisory or solicitation functions or who supervise those functions. Also included in the definition are persons who perform similar functions for SEC-registered advisors and who have a place of business in the state. Try this one. Example. 1. Which of the following individuals would be required to register with the administrator of a state? A. Walter, who represents a state-registered advisor, has no place of business in the state, and only serves existing clients who vacation in the state. B. May, who represents a covered advisor, has no place of business in the state and has 38 clients who reside in the state. C. Eliza, who represents a state-registered advisor, has no place of business in the state and had fewer than 6 individual clients who are residents of the state during the past 12 months. D. Joe, who represents a covered advisor, has a place of business in the state, and had 4 retail clients who are residents of the state during the past 12 months. Answer. D. Even though he represents a federal covered advisor, once an IAR maintains a place of business in a state, Joe must register in that state regardless of the number of clients. Walter need not register because he qualifies for the snowbird exemption. May qualifies for the exemption as an IAR of a federal covered investment advisor. She is only required to register in those states where she maintains a place of business. Eliza qualifies for the de minimis exemption. Fewer than 6 is the same as 5 or fewer. Important note, even if May's employer had a place of business in the state, she would not have to register because she, the IAR, doesn't. Of course, her employer, being federal covered, doesn't register in any states. 40 Unit 2 Regulation of Investment Advisor Representatives. S65_LEM.INT 40 the 15th of March 2019 10:57 and 55 seconds AM. Example. 1. Wealth Management Experts, WME, is an investment advisor registered in State X, the location of its only offices. During the past 12 months, WME has directed investment advice to 6 individual clients in State Y. This means that WME A is required to register in State Y because it has exceeded the de minimis limit. B is not required to register in State Y because it is within the de minimis limit. C does not need to register in State Y if that state has a reciprocal licensing arrangement with State X. D would be required to register in State Y as soon as advice was directed to a single retail client. Answer. A. What is the de minimis exemption? It is available to an investment advisor who does not maintain a place of business in the state and limits its business to 5 or fewer retail clients who are legal residents in the state during the preceding 12 months. That would make her the correct answer because 6 is above the limit of 5. There is no such thing as a reciprocal licensing arrangement between states. How would things change if the question was worded to say that there were 6 clients, 3 of whom were retail and the other 3 insurance companies? In that case, no registration would be required because the retail clients are within the de minimis limit, and there is no limit on the number of institutional clients an investment advisor can have in a state without the need to register, as long as there is no place of business in the state. Completing our examples, suppose you had a question like this on your exam. Example 1. An IAR representing a state-registered investment advisor would not qualify for the de minimis exemption in a state if, over a 12-month period, she had A. 5 retail clients, B. 5 or fewer retail clients, C. Fewer than 6 retail clients, D. 6 or fewer retail clients. Answer D. Because the maximum is 5 retail clients in a 12-month period, choice D with 6 clients is over the limit. Notice that fewer than 6 and 5 or fewer mean the same thing. Unit 2. Unit 2 Regulation of Investment Advisor Representatives 41. S65_LEM.IND 41 the 15th of March 2019 10:57 and 55 seconds AM. Registration requirements for investment advisor. Representatives. Unit 2 Describe the investment advisor representative registration requirements and process, post-registration filings, and business activities. As we learned with investment advisors, if you are not excluded from the definition of investment advisor representative or if you don't qualify for one of the exemptions, then you have to register. As pointed out earlier, it is only on the state level that an IAR registers, so we don't have the issue of comparing state and federal law as we do with IAS. Unless properly registered, it is unlawful for any registered investment advisor to engage the services of an individual as an investment advisor representative if that individual is required to register. This is true whether the investment advisor is state registered or federal covered. All IARs must be registered in at least one state. They have to have a place of business somewhere, right? Registration is accomplished by filing a Form U4. A Form U10 can be used in certain cases, but that is unlikely to be tested through FINRA-CRD, Central Registration Depository. Most of you have already completed that form, so you know it asks about your personal history and details. One of the most important parts is the DRPs, the disclosure reporting pages. It is on these pages that the applicant discloses past disciplinary events. The Form U4 requires disclosing if you have ever been convicted or even just arrested, charged, with no time limit, for any felony or securities-related misdemeanors. In Unit 5, we'll discuss how those can affect the application. Another important part of the Form U4 is the consent to service of process, mentioned earlier at Unit 1004 in conjunction with the registration of an IA. Here are two important items dealing with registration that are frequently tested. 1. The Uniform Securities Act states, registration of an investment advisor automatically constitutes registration of any investment advisor representative who is a partner, officer, or director, or a person occupying a similar status or performing similar functions. It isn't only the title that determines your registration, it is the function performed. Note that this quoted rule states that the partner, officer, or director of the investment advisor is an IAR. Doesn't that mean they are already registered? What is the purpose of automatic registration to someone already registered? When a state-registered IA expands its business so that registration is required in another state, or states, the application process is basically the same as their initial state registration. That is, a Form ADV is filed. That filing includes the names and other pertinent information about all of the partners, officers, or directors who are already acting as IARs. Therefore, when the firm's registration becomes effective in that new state, those individuals included in the filing are granted automatic registration. They don't have to file an individual Form U4. Please note, it is not any IAR, it is only those listed, or, as the rule states, those occupying a similar status, etc., who receive this treatment. Any of the firm's other existing IARs who will need to be registered in the new state must file an amended Form U4 with the administrator and wait for their supervisor to tell them that the firm has received the word that their registration is effective with that state. Here is the way this might be presented on the exam. 42 Unit 2 Regulation of Investment Advisor Representatives. S65_LEM.IND 42 the 15th of March 2019 10:57 and 55 seconds AM. Example 1. When an investment advisor registers in a new state, who of the following is automatically registered as IARs? A. Any employee who is functioning as an IAR in at least one state. B. Officers, partners, and directors of the firm who are functioning as IARs. C. Clerical employees stuffing the envelopes with research reports. D. Any employee who will be soliciting clients for the advisor. Answer B. As we just stated, the automatic registration provision applies to those officers, partners, and directors of the IA who are already IARs in at least one state. Important note, for those of you who have taken a FINRA exam, you know there is a supervisory level of registration registered principal. No such gradations apply under NASA rules. So, no matter how high-ranking the officer of the investment advisory firm, that individual registers as an IAR. Therefore, anytime you see reference made to your supervisor, remember, that person is an IAR just like you. 2. Testing. Unless a waiver is granted, see Introduction, passing the Series 65 exam, or the Series 66 exam, is a requirement for registration. We do expect you to pass, but, if an applicant is not successful on the first or second attempt, there is a 30-day waiting period before the exam may be retaken. After the third, and subsequent, attempts, the waiting period is 180 days. Now that you know how to register, what about termination procedures? IAR termination procedures. If an investment advisor representative terminates employment with an investment advisor, notification requirements depend on how the investment advisor is registered. If the investment advisor is a state-registered advisor, the firm must notify the administrator. If the investment advisor is a federal covered advisor, the investment advisor representative must notify the administrator. All notifications must be made promptly. A clue that might help is to visualize the I in IAR as the number 1 to remember that only one person gives notification. What is the story if the IAR leaves one firm to go to another? Example 1. Zach is an IAR with Unicorn Investment Advisors, UIA, an investment advisor registered in State W. Zach has accepted an employment offer from Elite Research Associates, EI, an investment advisor also registered in State W. What are the notification requirements to the State W administrator? A. Zach is the only person who notifies the administrator. B. UIA is the only person who notifies the administrator. C. ERA is the only person who notifies the administrator. D. UIA and EI notify the administrator. Unit 2. Unit 2 Regulation of Investment Advisor Representatives 43. S65_LEM.IND 43 the 15th of March 2019 10:57 and 55 seconds AM. Answer D. This is bit sneaky. We've just told you to remember that I in IAR resembles the number 1, so only one person must notify. We also stated that if the IAR represents a state-registered investment advisor, the IA does the notification. In this specific instance, because 2 IA firms are involved, each of them must notify the administrator, UIA, that Zach is no longer under their control and EI that Zach now is. This is just an example of how every rule has an exception. Financial requirements of IARs. Unlike an investment advisor, there are no financial requirements, no net worth or bonding requirements, to register as an investment advisor representative. Record-keeping requirements of IARs. Unlike an investment advisor, there are no ongoing record-keeping requirements for IARs. Annual renewal on December 31st requires the payment of fees. If there are any material changes, especially of a disciplinary nature, the individual's full NIEVES must be updated within 30 days. Test topic alert. If there should be a change to any material information in the full NIEVES, for example, change of permanent address or change to military status, an amendment must be filed within 30 days. Here is an example of how that might appear. Example 1. When an investment advisor representative's permanent residence address changes, updates must be made to the information on file with the regulatory bodies. The proper procedure to be followed is A. File a full NIEVES for within 30 days. B. File a full NIEVES for within 45 days. C. File a full NIEVES 5 within 30 days. D. File a full NIEVES 5 within 45 days. Answer. A. Amendments are made to the full NIEVES for and must be filed within 30 days. The full NIEVES 5 is for terminations. 44 Unit 2 Regulation of Investment Advisor Representatives. S65_LEM.IND 40 for the 15th of March 2019 10:57 and 55 seconds AM. Learning objectives. When you have completed this unit, you will be able to accomplish the following. U3LO1. Define a broker-dealer. U3LO2. Identify broker-dealer exclusions and exemptions under the Securities Exchange Act of 1934 and the Uniform Securities Act. U3LO3. Define an agent. U3LO4. Identify agent exclusions and exemptions under the Securities Exchange Act of 1934 and the Uniform Securities Act. U3LO5. Describe the initial and post-registration requirements of the Securities Exchange Act of 1934 and the Uniform Securities Act regarding broker-dealers and agents. Introduction. We have already discussed two of the for securities professionals covered under the Uniform Securities Act and federal law, investment advisors and those who represent them, investment advisor representatives. This unit will cover the other two, broker-dealers and those who represent them, agents. You can expect 4 questions from the unit. Who is a broker-dealer? U3LO1. Define a broker-dealer. When describing the exclusions from the definition of an investment advisor, Unit 1 LO1, we gave a brief definition of a broker-dealer. Let's get into more detail. 3. Unit. Regulation of broker-dealers and their agents. 45. S65_LEM_Chapter 3.INDD 45 the 7th of October 2019 10:47 and 21 seconds AM. A broker-dealer is defined in the Securities Exchange Act of 1934, the federal law regulating broker-dealers and their representatives, and in the USA as any person. Think back to the broad definition we gave you at the beginning of Unit 1, engaged in the business of effecting transactions in securities for the accounts of others or for its own account. Any person, example, a securities firm, even one organized as a sole proprietorship, with an established place of business, an office, in the state that is in the business of buying and selling securities for the accounts of others, customers, and or for its own proprietary account is defined as a broker-dealer. In other words, broker-dealers are firms for which agents, registered representatives, work. They are firms that engage in securities transactions, such as sales and trading. When acting on behalf of their customers, that is, buying and selling securities for their clients' accounts, broker-dealers act in an agency capacity. When broker-dealers buy and sell securities for their own accounts, called proprietary accounts, they act in a principal capacity as dealers. We'll cover their activity in this regard in Part 4, Unit 22. Take note. Individuals who buy and sell securities for their own accounts are not broker-dealers because they are engaged in personal investment activity, not the business of buying and selling securities for others. They are individual investors, not securities dealers. Test topic alert. One of the roles of a broker-dealer is underwriting, distributing shares of new securities for issuers. When they do that, they generally earn a spread, the difference between the public offering price and what they pay the issuer, or receive a commission on the sales, which they then use to pay their agents who actually made the sales to the clients. In Unit 4, we'll cover the registration and issuance of securities. Broker-dealer exclusions and exemptions. U3LO2. Identify broker-dealer exclusions and exemptions under the Securities Exchange Act of 1934 and the Uniform Securities Act. Exclusions from the definition of broker-dealer under the Uniform Securities Act. Broker-dealers are firms that buy and sell securities for others or themselves as a business. There are, however, many persons, legal and natural, that effect securities transactions that are excluded from the definition of broker-dealer for purposes of state regulation. Persons not included in the definition of broker-dealer are agents, those individuals who represent broker-dealers. Issuers, those entities, such as corporations and governments who raise money by issuing securities, and banks, savings institutions, and trust companies. 46 Unit 3 Regulation of broker-dealers and their agents. S65_LEM.IND 46 of 15th of March 2019 10:57 and 56 seconds AM. Today most banks and other financial institutions engage in securities activities through broker-dealer subsidiaries of the bank holding company. The broker-dealer subsidiaries of banks are, as a result, not excluded from the definition of a broker-dealer and therefore subject to the same securities regulations as other broker-dealers. Keep in mind that formation of these subsidiaries eliminates the need for the bank holding companies to register as broker-dealers. Their broker-dealer subsidiaries must, of course, register. Broker-dealers with no place of business in the state. This exclusion is very much like the one offered to investment advisors. States exclude from the definition of broker-dealer those broker-dealers that have no place of business in the state and deal exclusively with the issuers of the security involved in the transactions, other broker-dealers, and other financial institutions, such as banks, savings and loan associations, trust companies, insurance companies, investment companies, or employee benefit plans with assets of not less than $1 million, or have no place of business in the state, but are licensed in a state where they have a place of business, and offer and sell securities in the state only with persons in the state who are existing customers and who are not residents of the state. Similar to the rule for investment advisors and their representatives, the USA also allows broker-dealers and their agents to do business with existing customers who are temporarily in a state to avoid unnecessary multiple registrations. Example: as long as your client has not changed state of residence, there is no time limit. Many people, after a couple of years in the workforce, decide to get an MBA. If they go out of state to a resident program for a year or two, that does not mean they've changed their state of residence, merely that they are not commuter students. Only when official residency is changed, new driver's license or voter registration, does the 30-day rule apply. Test topic alert. Unlike investment advisors and their IARs, there is no de minimis exemption for broker-dealers. That is, even if the BD does not maintain a place of business in the state, a single retail client means registration is required. We'll cover one final exclusion, using the Internet. Obviously, there was no Internet when the Uniform Securities Act was written in 1956. As with other changes in the way we do business, NASA has written model rules to update the regulatory scheme. A firm's website, considered advertising, can be seen everywhere. Does that mean the firm has a place of business in the state? Without getting too technical, there are several requirements to ensure that the person is not deemed to be in the state. The communication clearly states that the person may only do business in this state if properly registered or exempt from registration. Any follow-up individualized responses with prospects in this state that involve either the effecting or attempting to effect transactions in securities, or the rendering of personalized investment advice for compensation, as may be, will not be made without compliance with state broker-dealer, investment investment advisor, agent, or IA representative registration requirements, or an applicable exemption or exclusion. Unit 3. Unit 3 Regulation of Broker-Dealers and their Agents 47. S65_LEM.IND 47 of 15th of March 2019 10:57 and 56 seconds AM. The site may only make available general information, not specific advice or recommendations. In the case of an agent or IAR, the affiliation with the broker-dealer or investment advisor of the agent or IAR is prominently disclosed within the communication. The broker-dealer or investment advisor with whom the agent or IAR is associated retains responsibility for reviewing and approving the content of any Internet communication by an agent or IAR. The broker-dealer or investment advisor with whom the agent or IAR is associated first authorizes the distribution of information on the particular products and services through the Internet communication, and in disseminating information through the Internet communication, the agent or IAR acts within the scope of the authority granted by the broker-dealer or investment advisor. What this basically means is that if you just generally advertise on the Internet, you don't have to be registered in the state. But, if you follow up with advice, IAR, or offering securities, agent, you either have to register or find some kind of exemption. Test topic alert. The exam focuses more on the exclusions from the definition of broker-dealer than on the definition itself. Know these exclusions well. Example exclusion from the definition of broker-dealer. First Securities Corporation, FSC, is a broker-dealer registered in State A, the location of its only office. One of their agents contacts a client who is currently on vacation in State B and recommends the purchase of XYZ common stock. The client agrees and purchases 100 shares of XYZ. Neither the broker-dealer nor the agent is registered in State B. Is this a problem? What if the client enjoys being in State B to the extent that it becomes his permanent residence? When a broker-dealer has no place of business in a state and deals with an existing client who is temporarily in that state, the USA does not define that entity as a broker-dealer in the state. Therefore, FSC would not be required to register in State B, and neither would any of its agents. Things change, however, if the client becomes a resident of State B. Once that client's residence has officially changed, the relationship can only continue for a maximum of 30 days. After that, both FSC and the agent would have to register in State B if they wanted to keep the client. Let's take the example one step further. A question might appear something like this. 48 Unit 3 Regulation of Broker-Dealers and their Agents. S65_LEM.IND 48 the 15th of March 2019 10:57 and 56 seconds AM. Example 1. First Securities Corporation, FSC, is a broker-dealer registered in State A, the location of its principal office. They have begun doing business in State B with the First Fidelity Bank and Trust Company and open a small branch office in State B to service the account. Which of the following statements is correct? A. FSC does not need to register in State B because its only client is an institution. B. FSC needs to register in State B because it has a place of business in the state. C. Broker-dealers are only required to register in the state where their principal office is located. D. FSC would have to register in State B even if it didn't have a place of business there. Answer. B. We learned that the USA excludes from the definition of broker-dealer a firm with no place of business in a state whose only clients are, among others, institutions, such as banks. That exclusion only applies when there is no place of business in the state. Opening a small branch in State B voids that exclusion. Even if there is no place of business in the state, if they have a single individual, called a retail client on the exam, who resides in the state, then registration is always required. Federal exemptions from registration as a broker-dealer. A broker-dealer that conducts all of its business in one state is exempt from registration with the SEC. The exception provided for intrastate broker-dealer activity is very narrow. To qualify, all aspects of all transactions must be done within the borders of one state. This means that, without SEC registration, a broker-dealer cannot participate in any transaction executed on a national securities exchange. Intrastate broker-dealers register with the state in which they are located. State exemptions from registration as a broker-dealer. The USA exempts a broker-dealer without a place of business in a state if its only transactions effected in the state are with the issuer of the securities involved in the transaction. Unit 3. Unit 3 Regulation of Broker-Dealers and Their Agents 49. S65_LEM.IND 49 the 15th of March 2019 10:57 and 56 seconds AM. Take note. Here is a chart that should help. The you here does not mean individuals like yourself, it is referring to the brokerage firm. Under the USA, you are a broker-dealer if, under the USA, you are not a broker-dealer if 1. You have a place of business in the state regardless of the nature of your clients, or 1. You have no place of business in the state and 2. You have even one retail client in the state too. Your only clients are other BDS, institutions, and issuers of the security involved in the transaction, or 3. You are registered in a state where you do maintain a place of business and only do business in this state with existing clients who are not residents of this state, snowbirds. Who are agents? U3LO3. Define an agent. Agent means any individual, other than a broker-dealer, who represents a broker-dealer or issuer in effecting or attempting to effect purchases or sales of securities. As agents, they act usually on a commission basis on behalf of others. Other than on this exam, agents are often referred to as registered representatives, whether they sell registered securities or securities exempt from registration. The use of the term individual here is important. Only an individual, a natural person, can be an agent. A corporation, such as a brokerage firm, is not a natural person, it is a legal entity. The brokerage firm is the legal person, legal entity, that the agent, natural person, represents in securities transactions. Take note. As just mentioned, agent is the term used under state law and that is the only term that will be used on the exam. Definition: associated person. A person associated with a broker-dealer is any partner, officer, or director of the broker-dealer, or any individual performing similar functions, or any person directly or indirectly controlling or controlled by the broker-dealer, including any employees of the broker-dealer, except that any person associated with a broker or dealer whose functions are solely clerical or ministerial shall not be included in the meaning of the term. Test topic alert. Even outside directors or partners whose only connection to the firm is the contribution of capital are considered associated persons of the broker-dealer. 50 Unit 3 Regulation of Broker-Dealers and Their Agents. S65_LEM.IND 50 the 15th of March 2019 10:57 and 56 seconds AM. Agent exclusions and exemptions. U3LO4. Identify agent exclusions and exemptions under the Securities Exchange Act of 1934 and the Uniform Securities Act. Clerical and administrative, sometimes referred to as ministerial, employees of a broker-dealer are generally not included in the definition of agent and, therefore, are not required to be registered. The logic for this exclusion from the definition should be obvious. Clerical and administrative employees do not affect securities transactions with the public. They attend to the administration of the broker-dealer as a business organization. Under these circumstances, they are like employees of any other corporation. In fact, if the broker-dealer they work for wishes to pay their employees, including this group, a year-end bonus based on company profits, not related to any individual's sales efforts, it would be allowable and would not require registrations of the clerical personnel. The situation changes when administrative personnel take on securities-related functions. When they do so, they lose their exemption and must register as an agent. Take note. Secretaries and sales assistants are not agents if their activities are confined to administrative activities, including responding to an existing client's request for a quote. However, if secretaries or sales assistants accept customer transactions or take orders over the phone, they are engaging in securities transactions and are subject to registration as agents. Test topic alert. Cold callers working for a broker-dealer would be defined as an agent if they did any more than ask if clients wanted to receive information. For example, if they pre-qualified clients or suggested ways to receive more money for their stocks or bonds, they would be considered agents. As is customary in other industries, broker-dealers frequently hire summer interns. If these interns received any selling-related compensation, such as $10 for each existing client solicited, they would be considered agents and would have to register. Basically, there is no way for an individual to represent a broker-dealer in a securities sales function without being an agent. Exclusions from the definition of agent for personnel. Representing issuers. In many cases, individuals who represent issuers of securities are agents and therefore must register as such in the states in which they sell the issued securities. When does something like this occur? In many cases, a local company is looking to raise some additional capital, something in the range of several $1 million. Instead of going through the normal investment banking procedure, and paying all of those fees and commissions to the investment bankers, the company, known under the USA as the issuer, either uses its own employees or hires an outside sales force to sell the new security. In general, these individuals are required to register as agents of the issuer. There is an exception as follows. Individuals are Unit 3. Unit 3 Regulation of Broker-Dealers and Their Agents 51. S65_LEM.INT 51 the 15th of March 2019 10:57 and 57 seconds AM. Excluded from the definition of agent and, therefore, are exempt from registration in a state when representing issuers in effecting transactions, in certain exempt securities, the 5 listed below, exempt from registration, or with existing employees, partners, or directors of the issuer if no sales-related commission or other remuneration is paid or given directly or indirectly for soliciting any person in this state. Effecting transactions in exempt securities. Securities exempt from registration are called exempt securities. Although there are almost a dozen different securities that qualify for exemption under the Uniform Securities Act, they will be discussed later in Unit 4. An individual is excluded from the term agent only when that individual represents an issuer in effecting transactions for the following 5 exempt securities. 1. Any security issued or guaranteed by the United States, any state, any political subdivision of a state, or any agency of one or more of these or any security issued or guaranteed by Canada, any Canadian province, or any political subdivision of any such province. 2. Securities of foreign governments with which the United States has diplomatic relationships. 3. Any security issued by, or guaranteed by, any bank organized under the laws of the United States, or any bank, savings institution, or trust company organized and supervised under the laws of any state. 4. Commercial paper rated in the top 3 categories by the major rating agencies with denominations of $50,000 or more with maturities of 9 months or less. 5. Investment contracts issued in connection with employee stock purchase, savings, pensions, or profit-sharing plans. Effecting exempt transactions. An employee of an issuer is not an agent when representing an issuer in exempt transactions. Transactions exempt from registration are called exempt transactions. Some examples are unsolicited brokerage transactions, transactions between the issuer and underwriters, transactions with financial institutions, or private placements. Exempt securities and exempt transactions will be covered in thorough detail later in Unit 4, so you will probably want to come back and review this information after that. Take note: an employee of an issuer is not an agent when representing an issuer if the issue is exempt from registration, as long as it is one of the 5 listed previously. Additionally, the employee is not an agent when representing an issuer in exempt transactions, example, transactions between an underwriter and issuer. 52 Unit 3 Regulation of broker-dealers and their agents. S65_LEM.IND 52 the 15th of March 2019 10:57 and 57 seconds AM. An individual employed by a corporation, not a broker-dealer, to sell a new initial public offering, IPO, to the public would be considered an agent of the issuer needing registration, even if not paid compensation based on sales. The only exception would be if all transactions were exempt, such as selling the shares only to institutional investors. Take note. Keep in mind that an individual who works for an issuer of securities is excluded from the definition of agent when engaging in transactions with employees involving the issuer's securities, provided that the individual is not compensated for such participation by commissions or other remuneration based either directly or indirectly on the amount of securities sold. In other words, salaried employees engaged in distributing their employer's shares as part of an employee benefit plan would not be required to register as agents because they are, by definition, excluded from the definition. If such employees were compensated on the basis of the number of shares sold, they would be defined as agents and therefore would be subject to registration. Test topic alert. Individuals representing broker-dealers in a sales capacity must register as agents whether they sell registered securities, securities exempt from registration, or securities in an exempt transaction. Agent exemptions from registration. Just as with broker-dealers, there is no de minimis exemption for agents. If you have a single client in a state, regardless of whether or not you have a place of business there, you are an agent in that state and require registration. There are only 2 exemptions. First is the snowbird exemption we've discussed several times before. The second is when the firm is excluded from the definition of BD because it has no place of business in the state and only deals with other broker-dealers and institutions, etc. In that case, the BD's employees who service those clients are not considered to be agents in that state. Example. 1. Under the Uniform Securities Act, which of the following would be considered an agent? A. An individual who is employed by a small community bank for the purpose of selling stock in the bank. B. A broker-dealer with a place of business in the state with an extensive retail clientele. C. An individual whose broker-dealer is registered in the state, but her only clients are institutions. D. An individual with no place of business in the state dealing with more than 5 existing clients who are vacationing in the state. Unit 3. Unit 3 Regulation of broker-dealers and their agents 53. S65_LEM.IND 53 the 15th of March 2019 10:57 and 57 seconds AM. Answer. C. Even though the individual's only clients are institutions, the fact that her BD is registered in the state means she must register as well. Yes, transactions with institutions are exempt transactions, but that exemption only applies to individuals selling on behalf of the issuer, not when representing a broker-dealer. Individuals selling the securities of certain exempt issuers, like a bank, are excluded from the definition as are broker-dealers. If the individual has no place of business in the state and only deals with existing clients, regardless of the number, who are temporarily in the state, that individual is exempt from registration. Broker-dealer registration requirements. U3LO5. Describe the initial and post-registration requirements of the Securities Exchange Act of 1934 and the Uniform Securities Act regarding broker-dealers and agents. Under the USA, If a person is included in the definition of a broker-dealer, that person, unless meeting one of the exemptions we've discussed, must register as a broker-dealer in the states where it does business. The USA is clear about broker-dealer registration. It states, it is unlawful for any person to transact business in this state as a broker-dealer, unless he is registered under this act. This means every person, legal entity, that falls within the definition of a broker-dealer must register with the administrator of the state. Again, keep in mind that if a person falls under one of the exclusions from the definition, that person or legal entity does not have to register in the state. The rules are basically the same for agents. In most jurisdictions, registration is accomplished by filing the SEX Form BD modified to meet the needs of the state. If any material information on the BD becomes inaccurate, prompt notice must be given to the administrator. While the exam will focus on state registration requirements, you need to know that almost all broker-dealers register with the SEC. That means, unlike investment advisors who only register with one regulator, you can assume that any broker-dealer referred to in a question, unless something tells you otherwise, registers with the SEC in at least one state. Take note. The automatic registration of officers, etc. that we discussed with regard to investment advisors applies here as well to those who are registered with the BD. And, as mentioned before, unlike FINRA, there is no separate principal registration, so these individuals are registered as agents. Submitting an application. All persons must complete and submit an initial application, as well as renewals, to the State Securities Administrator. For broker-dealers, the application is Form BD, and for agents, Form U4. The application must contain whatever information the administrator may require by rule, and may include form and place of business, broker-dealers. 54 Unit 3 Regulation of broker-dealers and their agents. S65_LEM.IND 50 for the 15th of March 2019, 10:57 and 57 seconds AM. Proposed method of doing business. A list of all jurisdictions in which the applicant is registering, or already registered. Qualifications and business history. Broker-dealers must include the qualifications and history of partners, officers, directors, and other persons with controlling influence over the organization. Court-issued injunctions and administrative orders. Adjudications by the SEC or any securities SRO, such as FINRA, within the past 10 years. Convictions of misdemeanors involving a security or any aspect of the securities business, including charges as well as convictions. Felony convictions, whether securities related or not, including charges as well as convictions. Financial condition and history, broker-dealers only, but only of the firm, no credit reports on the officers. Any current unsatisfied liens and judgments must be shown, as well as any declaration of bankruptcy within the past 10 years. Any information to be furnished or disseminated to any client or prospective client, if the applicant is an investment advisor, and in the case of an individual registrant, agent or investment advisor representative, citizenship information. The administrator also may require that an applicant publish an announcement of the registration in one or more newspapers in the state. Test topic alert. Please note that, unlike FINRA registration requirements, individuals applying for registration do not have to submit fingerprints. Before we continue, an important term found in the Securities Exchange Act of 1934 needs to be defined: statutory disqualification. Because the Exchange Act deals with the registration of persons and exchanges, the People and Places Act, the SEC sets forth certain actions that a person disqualified under statute, law, from becoming registered or associated with a broker-dealer or investment advisor. The person is subject to a statutory disqualification if that person has been or is expelled or suspended from membership or being associated with a member of any self-regulatory organization, SRO, think FINRA, is subject to an order of the SEC or other appropriate regulatory agency, think the administrator, denying, suspending, or revoking his registration as a broker-dealer, or barring or suspending his association with a broker or dealer. By his conduct while associated with a broker-dealer has been found to be a cause of any effective suspension, expulsion, or order of the type described in the two previous points. Has been convicted within the past 10 years of a securities violation or a misdemeanor involving finance or dishonesty, bribery, embezzlement, forgery, theft, and so forth, or any felony. Is subject to a temporary or permanent injunction from a competent court of jurisdiction prohibiting him from engaging in any phase of the securities business. Unit 3. Unit 3 Regulation of Broker-Dealers and Their Agents 55. S65_LEM.IND 55 the 15th of March 2019 10:57 and 57 seconds AM. Has willfully violated any federal securities law, or has made a false or misleading statement in any filing with information requested by an SRO, omitting important facts is cause as well. Take note. Loss of a civil lawsuit, even involving securities, is not a cause for statutory disqualification. Payment of initial and renewal filing fees. States require filing fees for initial applications as well as for renewal applications. If an application is withdrawn or denied, the administrator is entitled to retain a portion of the fee. Filing fees for broker-dealers, investment advisors, and their representatives need not be identical. A registered broker-dealer, covered advisor, or state-registered investment advisor may file an application for registration of a successor, whether or not the successor is then in existence, for the unexpired portion of the year. There is no filing or registration fee until renewal, December 31st, of the firm's license, but the successor firm would have to file a new consent to service of process. Under normal circumstances, registration becomes effective for all securities professionals at noon of the 30th day after filing. In the case of agents, or IARs, the administrator will notify the employing firm of effectiveness, and they will tell the new registrants when they are good to go. Once registered, broker-dealers are subject to numerous administrative requirements to keep their registrations current and in good order. Books and records. Every registered broker-dealer must make and keep such accounts, blotters, records of original entry, correspondence, including emails, memoranda, papers, books, and other records as the state administrator by rule prescribes. All records so required must be preserved for 3 years, the first 2 years easily accessible in the principal office, unless the administrator specifies otherwise. These records must be current, complete, and accurate. Broker-dealers are obligated to promptly file correcting amendments. State securities administrators cannot impose record-keeping requirements that are in excess of those prescribed by the SEC. The records broker-dealers are required to maintain are subject to periodic, special, or other examinations by representatives of the administrator of the state where the broker-dealer's principal office is located or of any other state in which the broker-dealer is registered as the administrator deems necessary or appropriate in the public interest. Test topic alert. Included in the record-keeping requirements are electronic communications, particularly emails. However, it is not required to maintain emails of a personal nature sent to non-clients. Example, honey, I'm stuck at the office and will be late for dinner. 56 Unit 3 Regulation of Broker-Dealers and Their Agents. S65_LEM.IND 56 the 15th of March 2019 10:57 and 57 seconds AM. Website storage. Websites are treated as would be any other advertisement. So, the original site design is kept for 3 years and, whenever revised, the new copy is maintained and starts a new retention requirement for that copy. Therefore, the firm will likely have several different versions in its advertising file at the same time. Test topic alert. Although broker-dealers and investment advisors are required to keep all records relating to customers, there are no requirements to keep copies of the customer's tax returns. Financial requirements for broker-dealers. The administrator may establish net capital requirements for broker-dealers. Net capital requirements of the states may not exceed those required by federal law, in this case, the Securities Exchange Act of 1934. The administrator of a state may require those broker-dealers that have custody of, or discretionary authority over, clients' funds or securities to post surety bonds. Just as with net capital, the amount of surety bonds required by the states is limited to the amount set by the Securities Exchange Act of 1934. No bond may be required of any broker-dealer whose net capital exceeds the amounts required by the administrator. Stated simply, when it comes to broker-dealers, regardless of how many states in which they are registered, other than enforcing anti-fraud statutes, the administrator has relinquished most control to the SEC. Test topic alert. You will have to know that broker-dealers who meet the SEC's net capital or bonding requirements cannot be required to meet higher ones in any state in which they do business. Test topic alert. In lieu of a surety bond, the administrator will accept deposits of cash or securities. Agent registration requirements. The registration requirements for an agent who is not exempt are similar to those for a broker-dealer. An application, generally the Form U-4, must be completed. One thing, however, that is on the agent's application that does not apply to a broker-dealer is disclosing citizenship. The USA states, it is unlawful for any person to transact business in this state as an agent unless he is registered under this act. In other words, an individual may not conduct securities transactions in a state unless that person is properly registered in the state where he conducts business. This is true even when receiving unsolicited orders. If an agent does business in a state, she must be registered in that state, even if there is only one client. This is not like investment advisors and their representatives who enjoy a de minimis exemption. So, what can an individual who has been hired to become an agent of a broker-dealer do? While registration is pending. After all, one does not fill out the Form U-4 and become an Unit 3. Unit 3 Regulation of Broker-Dealers and Their Agents 57. S65_LEM.IND 57 of 15th of March 2019 10:57 and 57 seconds AM. Agent immediately. Permitted activities would be those allowed to any other employee of the broker-dealer who is not required to be registered. That would include clerical functions, such as posting trade details to client accounts, or administrative activities, like assisting with research. As long as it does not involve customer contact relating to selling, offering securities or opening accounts, these newbies can hang around the office and try to make themselves useful. Of course, most of their time should be spent preparing to pass the exam. An agent's registration is not effective during any period when the agent is not associated with a broker-dealer registered in the state. Therefore, if the broker-dealer